Yes. Lunch motion. Ah, which order? All right. How many? How many cases? Ah,
My lord, the medical admission matter, my lord, filed an application for expert hearing. Urgency is, my lord, that we lost already one academic year. There's possibility of losing one more year. My lord.
so it will come up on orders on IA.
I already filed an application.
So on 27 September. You want final hearing? It's not possible. Move an application like him, early hearing. 2021 November, sometime in November it will come. Now application will come for consideration on, we'll say 16th October.
Your Lordship, I may be permitted to move a lunch motion, Your Lordship. It's against the closure orders, Your Lordship, without issuing closure orders for the were issued.
Industry.
Yes, Your Lordship.
Oh, you are must be polluting, right? Polluting the environment. They must have deliberately this thing not given you notice and close so that you can obtain a stay, and this will remain pending for 25 years, right? You submit to Monday, nothing happens. Monday. Deliberately,
Today.
without notice on this thing, deliberately, so that you go and obtain stay. Monday.
That's it. Sleep for posting, the petition dismissed for non-prosecution on 15th.
No urgency. That shows itself shows 5/10, 5th of October. Yes. See, I mean, the pollution control board doesn't know that you have to give notice deliberately. Just to help the industry that you go to the court and get stay, and this petition will remain pending for so many years. So you will, industry will know.
May I please your lordship?
Yes, correct.
May I please your lordship? I am representing Raja Irajuddin, my lord, appearing for appellant.
Yes. Which item 1?
Item 1.
Yes.
May my lord, this writ appeal filed against the order passed by the learned single judge. The appellant is the petitioner. Petitioner filed the writ petition questioning the appointment of the fourth respondent as Mutavalli, which has been under section 42 of the Waqf Act 1995. My submission was before the learned single judge was that I was given representation in the year 2020, and I filed a writ petition number 5878 of 2021. The order is on page number 56 and 57.
So what is the point?
And this honorable learned single judge directed to, your lordship kindly see page number 57.
No, we would like to, you are claiming your appointment as hereditary Mutawalli.
I am claiming as
of law?
Mutawalli.
Which way?
Under section 42 of the Waqf Act,
You have
the person who are in the possession and managing the institution. Waqf Act, my lord.
95.
95.
Section?
42, my lord. In the case of change in the management of to be notified, in the case of any change in the management of the registered Waqf due to the death or retirement or removal of the Mutawalli, the incoming Mutawalli shall forthwith and any other person may notify the change to the board. In the case of any other change in any of the particulars mentioned in section 36, the Mutawalli shall within 3 months from the occurrence of the change notify such change to the board. 36 related to properties, if any change in the. I was given the representation in 2020, my lord.
No, that section 42 does not speak of your right that you petitioner has to be appointed Mutawalli. Doesn't say so.
I am recognizing me as a Mutawalli because I am
as we understand from reading of this provision 42(1), that in case there is a death, retirement or removal of a Mutawalli, the incoming Mutawalli shall notify the change to the Waqf board.
But I have given
that does not provide for your appointment. You said that I am entitled
I
under
am,
42.
because I am came in the shoes of my father, I am
No, no,
managing
which is the provision of appointment of this thing?
that appointment of provision is section 63.
60. So your application for appointment has been rejected. Why?
Not at all rejected. I filed writ petition.
He has been appointed. No other.
He has been appointed.
Then
They are all, he is also appointed under section 42. My lord, kindly see the impugned proceeding. Impugned proceeding at page number 80, my lord. Page number 80. The
63.
fourth respondent also appointed
No,
under.
no. So what is? So he has been appointed. Your application is pending. So
My-
you also want appointment, right? So what is wrong with the order? This is an intra-court appeal. What is wrong with the order?
My submission is it wrong in the order is that your lordship kindly see page number 32, my lord, running index, internal page 18,
Hmm.
a bare perusal conclusion, my lord, para 9, a bare perusal of the detailed report dated 5/8/2021 of the Inspector Auditor Rangareddy addressed to the Chief Executive Officer, Telangana State Waqf Board, Hyderabad, clearly indicates the fourth respondent was recognized and appointed as Mutawalli of the subject Waqf institution under section 42 of the 1954 Act. Whereas 1954 Act already repealed, my lord, by virtue of section 90, Waqf Act 1995, related to the section 63 of the Waqf Act 1995, and the same is extracted here on. Where there is a vacancy in the office of.
Just now you have read it, right? Section
Pardon?
63.
My
You have
lord.
read it. What is wrong with the order? We are asking you what is wrong with the order. You are reading the order.
That's
Please
a-
tell us what 1, 2, 3 points this.
My submission is that, my lord, the learned singer judge has been taken into consideration, the inspector report, but my submission was that this honorable court, as learned single judge of this honorable court, has order to conduct inquiry for consideration of my application that has not been done by the Waqf board. That is not considered, my lord. And the order passed by the Waqf board is under section 42 of the Waqf Act 1995. For a moment, the proceeding sees that if it is under section 63, there must be a tenure must be prescribed, my lord. That has not been considered, my lord. And under section I have submitted before the learned single judge, the inquiry to be conducted under section 70-71. The inspector report is not at par of section 70-71. The inspector report is internal report they have that, not by virtue of the compliance in the order passed by the dishonorable court. For a moment, my lord, the order of dishonorable court may consider, my lord. I request, my lord. Page number 57, 57, my lord.
Hmm.
My lord, 57, there are two.
We will admit it. Admit the petition. Heard on the question of admission. Learned counsel for the
Interim direction, interim
What
suspension.
interim? Ah,
That the
you want argue on what stay should be granted, that he should be prevented from. We have given them 3 weeks time to file reply to this. Thereafter, your IA will be considered. If you want that, they should not be given time, and today itself the order should be passed. We are ready to decide. You decide.
No, I am leaving it to your lordship.
We have given them 2 weeks time. He has already been appointed. You understand, right?
I am also
cannot-
managing the affair. There are only
You
classes are there.
Manage. Let them file reply to this.
Much obliged.
And that's.
So order it. Heard on the. Yes, that's what. We appreciate this fairness. Like, we have got this order, but we wanted to hear this from you. Same, disposed of. One. 3 is also same. 2 and 3.
Is not.
3.
The 3 and 5, your lordship.
3 and 5. Yes, he is saying same. You are saying no.
Say no.
He also will join you in going to DRT. That's
Saying
no, no.
Is it not in no?
We are telling you that he will also go along with you to DRT. That's what he's saying.
Yeah, I'm already there in the, in my case.
Huh? You don't appreciate the humor. What can be done, mister? All right, fine. 4.
The 3 and 5,
3 and 5. Yes, same order.
much of.
File and appeal. Yes.
Lordships, the petitioner was allotted college, lordship, she could not report on time, lordship.
Yes, mister.
On 5/9, she has to report it, lordship, she could fail to report.
Yes.
Rule 4 and 4.
This we see order, mister. You know, this order binds us.
Lordships.
Delay. You ask him to prepare this thing.
Lordships, she appeared, she was allotted seat, lordship, but she could not report to the college.
That's why we have. Have you challenged the validity of the rule?
I have challenged the validity of the rule.
We have already upheld the validity of the rule.
Lordships, what?
It's the order.
Lordship, the other day, your lordships.
Mister, in your case only. Then how can you argue?
No, I'm not arguing, lordship, I'm just bringing the facts, your
No,
lordship.
this.
Let that my representation may be disposed of, lordships, if they may consider my representation.
Really, what representation?
I made
It is
representation.
for Mr. Rao to consider. We cannot direct
Because-
this thing. We will not direct, Mr.
Lordships, I have addressed the
You have
representation.
challenged GOMS 114 validity of GOMS has already been upheld by this court.
One submission, lordships, I just, UMS 125 is given for seat blocking. The main criteria for GOMS number
No,
1.
this 114, Mr. GOMS 114 is that this thing, no 2017 rules.
2017.
We have read down it by order dated 29/8,
Lordship.
and we have then thereafter dismissed the rate petition on the ground of delay and latches.
That is
Same
for,
thing.
lordship, that is for local and non-local, lordship. This is, lordship, I have applied, I have allotted seat. I could not report the college within time.
Also, rule 4 does not empower.
Rule 4, small Roman 4.
Bars, yes.
Pass me. I one submission, lordship, I page
Mr. See
25.
this order. You are the council. I mean, I
I am
don't know how.
I'm not coming in your way, lordship, I just,
No question. Nobody can come in our way.
lordship, what I
But
just,
see, what we are asking you, we thought that you are a reasonable person, right? You are the council. In your case, the petition has been dismissed. Again, you are arguing.
I'm not arguing.
Then, what we are trying to tell you, we will hear you for rest of the day till 4:30.
You
But
said that,
thing is that this order binds us. We cannot take a different view, right?
lordship, this order binds, lordship. One submission and I leave it to your lordship.
Binds you also. You are the council. You have been heard.
One submission, lordship, for a minute, one submission. I don't take much. Page 25, lordship, for a minute, page 25. Lordship, page 25, one line, lordship, and I leave it to your lordships. Lordship, first paragraph, difference third paper, as per the recommendation constituted to prevent seat blocking. Lordship, I am here, I want to take a seat here.
Why did you not report?
Lordship, sir.
When were you allotted?
Lordships, I have stated so, lordships.
When were you allotted a seat?
Lordships, I was allotted seat, lordships, on 2/9, lordships.
2/9?
2/9 is the date.
No, Mr. Rao, when she was asked to report, he or she, who is?
I should be
She,
reported.
when she was asked to report,
2-9 I have to report.
Full line is there.
when had to report, did not report.
Lordship, I could not report, Lordship.
You withdraw the petition with the liberty to file a representation, that is fine. But
Lordship,
this
already
order,
I submitted my representation, Lordship. I'm just consider. Let them consider my representation.
in this writ petition, comma, the petitioner who is an aspirant for admission to MBBS. Yes, madam, it's a consent order.
I represent.
How an intra-court appeal?
Appeal to the respondent. It's a
My
consent.
my lord, I represent the appellants, my lord. Special
It-
counsel is
no,
under
no,
my
no,
lord.
whatever.
He requested for 2 weeks.
Query is, it's a consent order. You read the order.
Paragraph 2 may not be considered.
Consent order, how appeal lies. You file review.
Should we say 2 weeks, my lord? I'll
No,
clarify.
nothing. Madam, these cases are not listed for seeking adjournment all the time. You are competent enough, we are sure, to understand that this is an order passed on consent. Read the order. Page 17. Please read.
I'm sorry, my lord.
Please read.
I'm sorry, my lord. I am
You don't
unable
have
to
file.
con-
I'll get the copy.
Yes, ma'am.
Please read the order. Read it aloud. Read for us. We have not read it. You please read that.
Yes, ma'am.
Learned counsel for petitioner. Read.
In view of the same, both the writ petitions are disposed of, setting aside endorsement of.
Read from the beginning.
Yes, ma'am.
Ah.
The learned counsel for the petitioner on both writ petitioner submits that the government has issued GOMS number 279, Revenue Department dated 4/7/2016. Pursuant to the same, government has issued a memo dated 6/3/2008 on, and that
18,
these.
not 18. 26/3, 6/3/2018.
2018.
Ah.
And these writ petitions can be disposed of, directing the respondent to consider the same in the petition in terms of aforesaid GOs.
Then
The same is not disputed by the assistant governor pleader for the revenue.
consent order. So how writ appeal? There is no element of adjudication. If you are aggrieved, your remedy is to file a review if concession was wrongly given. Correct?
Yes, ma'am.
This simple thing. That's why we are not adjourning. Simple, you understand this. There is nothing to argue in this case. We will dispose of your appeal with the liberty to file an application for review if so advised. Right?
No, they are not even raised that in the grounds, not that it was wrongly given consent. Nothing is, they have not said anything at all.
My lords, my
We'll
submission.
say yes. No, nothing. You
Okay.
want us to record the submission that you are making a prayer for adjournment and we have rejected it. or you want us to mark your presence? You have understood, madam. There is nothing to
My
argue.
lordship may say Monday. We go Monday. Monday.
We have something better to do on Monday. The other cases are fixed, madam. Please see if there would have been a debatable point and which requires a preparation, then we would have definitely accommodated. This is not, you have seen it.
My lord, can I submit?
This intra-court appeal is filed against
My
an
lord, can I
order.
submit, my lord? Can I submit?
No,
The concerned MRO, my lord, that.
no. Madam, we are holding that it's order passed on the basis of consent of the parties. Appeal, intra-court appeal does not lie. There is no element of adjudication. This intra-court appeal under clause to mark their presence. They heard. Same item number 10 and 8010.
810, 810.
810. What about remaining two?
Those two are, my lord, by some third party taking leave to file appeal for substance.
Which 7? Then call Madam 7. Those 6, 10 and 11 are decided.
Yes, ma'am.
And then 7, 10, 7. Please.
Lordship has granted a leave for reviewing.
You can file, you can advise, madam. There's no question of filing a review. There's no question of
Because
granting leave.
Because in this we have. not
Needless
brought
to state, you're right, madam. Needless to state that the petitioner shall be at liberty to take recourse to such remedy as may be available to them in law.
So these appeals where leave is sought are by private party. They are not concerned.
No, these are, in their order, we have only said that they are at liberty to take recourse to such remedy because we have said it's not.
That's what the apex court said, my lord, whenever such concession is made, you only have to file a review application.
Yes,
A reported judgments, my lord, which is
Yes.
followed by our court.
you, so what stage we have brought her? She was seeking adjournment. What to do? Yes.
So this writ appeal
Yeah.
566,
My instructions were to take 2 weeks adjournment, my lord.
We have refused. You want still we can say. There is nothing to argue, madam.
Yes, my lord.
We mentioned. Item number, now next, madam, call 6, 7,
I think 8.
item 7.
Writ appeal 566, my lord, item 8.
No, this is now 531 has been decided.
Yes,
We have called 532.
that is all same. Against two common order. What you also past order is a common order
All right, same. That,
which will annul for these two.
Yes. Rate petition number, etc. will change, right? Item 8.
8, my lord, is by a private party
Call,
seeking leave.
madam.
I am representing petitioner in
Yes.
number 8 and 9, my lord.
Yes. What is it?
My lords, I am representing a petitioner in the item number 8 and item number 9.
Yes.
Senior counsel is
Petitioner,
appearing.
appellant.
Appellant.
Ah.
Senior counsel is appearing for this matter, my lords. I
Senior-
humbly request you to grant 2 weeks time.
You are not able to, my lord.
Senior counsel is appearing in this matter, my lords. I humbly request you to grant 2 weeks time for.
You said you are appearing?
I'm representing,
Appearing
my
means we expected that you will start arguing the case. You are appearing to inform that it is to be adjourned.
Yes.
What is it, Mr.? You are a party in the petition?
May I clarify, my lord, for lord's consideration? This is by a third party to the writ petition who seeks leave to file writ appeal against a consent order of writ petition. So this is not maintainable. Writ appeal itself is not maintainable.
Yes,
The
Mr.
third party is coming for a
We have
leave.
already held. You initiate appropriate proceeding for adjudication of your grievance. You are not a party. Writ appeal does not lie. And Supreme Court says 63 Supreme Court that this, you can file a writ petition saying that this order doesn't bind me. If a person is not a party to an order,
That taken.
that is maintainable.
That's obvious.
What is that citation? AIR 63 Supreme Court?
My lord, I immediately citation I can't.
63,
I'm poor
huh?
as,
63 Supreme Court, yes. Mark the, this intra-court, this appeal has been filed
My lord, again, another call.
or item number 9 saved.
That's all.
10 and 11, we have already passed a note. 12. Yes. Yes, madam.
Malas, the present writ appeal is filed against the order of the learned single judge.
Yes.
On
They
the
have
last
granted
date-
residential district permission. So we asked you on the last date, madam, which provision the
Yes, Yes, my lords.
Which-
My lords, under chapter 12 of the GHMC Act, my lords,
Yes.
the entire chapter
Which,
12,
which provision?
my lords, under 428, my lord, any person who is interested, has an intention to construct make any construction on a piece of land has to give notice to the commissioner, my lords. Thereafter, under 429 and various other sections, the commissioner has the power to either ask for additional documents such as plans or other building requirements, my lords. And ultimately, under 437 and 438, my lords, the commissioner has the power either to reject such application for making of building constructions. There is also a deeming sanction under 437, my lords. And under 438, my lords, even if the commissioner rejects it, but if he gives the permission to construct the
And
building,
there is no appeal, right?
there is no appeal, my lords. The only appeal provision is under section 450, my lords.
Heard on the question of admission.
May I please the lords, I beg to appear on behalf of Tandav Yogesh, my lords.
Huh?
My lords, plus the present writ petition is filed, my lords, challenging the notification issued by the respondent to rejecting the petitioner's application for the written examination of junior civil judge, my lords. Whereas the remark says that, my lords, applicants from serial number 1 to 6 doesn't fall prior to the 3 years under 3 years category for before the notification, my lords. My lords, but whereas, my lords, I would like to take my lordships to page number 40, my lords.
Ask him. Ask him. But see, you refer to page 9. In the table, you have mentioned that the notification is 1/2/2023.
Yes,
So
sir.
he must possess a degree preceding 3 years before that.
Yes, my lords.
You have acquired degree on in the month of November 2019.
19, my lord.
So that is, it goes beyond 3 years.
That
Please
is-
calculate, please calculate.
Yes, my lords, I would like to take your lordships to page number 11, my lords, the relevant portion of India Judges Association versus Union of India, my lords. My lords, here, even fresh graduate who doesn't, my lords,
You are challenging the condition in the notification.
not condition, my lords, I have been, no, my lords,
You will
I have
have to-
applied for the,
1 minute.
yeah, my lords.
The problem is that we have to pass an order. You will have to listen to us, right? We
So, sorry, my
if you don't want to answer the query, argue whatever you argue. All India judges.
lords, I put it here, my lords.
You don't want to hear. That's the problem. You don't want to hear. We want to be in this thing. We want this to be an interaction. But when the council is not prepared, we keep quiet and just hear him.
No, my lords.
There is nothing, Mr. See, all the cases we are trying to find a solution within 4 corners of law. It is the council who takes it personally that no, this stay should not be modified or vacated. He argues like as if, so like this is what it is. What can be done? You argue your own way.
My lords, page number 11, my lords, the relevant portion of the judgment, my lords. If I may permitted to read, my lords. In All India Judges Association versus Union of India, this court has observed that in order to enter the judicial service, an applicant must be an advocate of at least 3 years standing. Rules were amended accordingly. With the passage of time, experience has shown that the best talent which is available is not attracted to the judicial service. A bright young law graduate after 3 years of practice finds the judicial service not attractive enough. It has been recommended to the Shetty Commission, after taking into consideration the views expressed before it, the various authorities, that the need for an application to have been an advocate for at least 3 years should be done away with. After taking all the circumstances into consideration, we accept this recommendation of the Shetty Commission and the argument of the learned amicus curiae that it should be no longer mandatory for an applicant desirous of entering the judicial service to be an advocate for at least 3 years standing. We accordingly, in the light of experience gained after the judgment in all India judges cases, direct to the high courts and to the state governments to amend the rules.
Where are you reading? Which?
Page number 11, my lords.
Yes. Yes.
We accordingly, in the light of experience gained after the judgment in all India judges case, direct the high courts and to state governments to amend the rules so as to enable a fresh graduate who may not even have put in 3 years of practice to be eligible to compete and enter the judicial service. We, however, recommend that a fresh recruit into the judicial service should be imparted training of not less than 1 year, preferably 2 years. Also, in this case, my lord, the petitioner has completed a degree in 2019, where she has got a provisional degree on 28 to 2020, my lords. Whereas a notification got issued in 2023, my lords. This applying this apex court judgment, my lords, even a fresh graduate who has passed, say, my lords, the petitioner has been passed in the year 2023. And the same, the notification has also been issued in 2023, my lords. Even the fresh graduates are allowed for the exam, my lords. Whereas here, the petitioner has applied for the exam. She was qualified for the preliminary exam. She applied for the written mains examination, my lords, where her application got rejected in the mains examination, stating that her the remark is shown as, my lords, candidature of applicants at serial number 126 are rejected as have not acquired the law degree within the 3 years prior to the date of recruitment, whereas she has already been graduated in the year 2020 only, my lords. And she also saw, my lords, similar instances, my lords. The batch of writ petitions pending before this honorable court, my lords, allowing the petitioners to appear for the written examination, my lords. I have also included the various writ petitions in my affidavit, my lords. It's on page number 80, my lords. There were similarly placed candidates who challenged this same kind of thing, my lords, and they were allowed to appear for the examination.
Anything else?
My lords, one submission, my lords. My lords, the similarly placed candidates have been submitted the.
This is actually incorrect submission that they are similarly placed. We will assign reasons for rejecting your petition. Anything else?
My lords, here the remarks were given as the petitioner has not completed a degree prior to the 3 years of the
anything,
my lords.
That we know.
My lords,
anything else?
I close my submissions, my lords. But my lords, the petitioner has also given a representation to the respondent number 2, my lords, to consider representation. The fact is, my lords, if at all the petitioner,
if you are not entitled, nobody can permit you.
My lords, one submission. If at all the petitioner is not eligible, my lords.
High Court is not university, right? High Court is not university. Mr. Rao can do anything, but we can't do anything. Yes.
One submission, if I may permit it.
Lighter vein, Mr. Rao. Nothing like, don't take it. Lighter vein, I say. We say always to make the atmosphere cordial, because people get so serious as if they are being hanged by neck. So we try to say something to make the atmosphere cordial. That's all. Nothing.
One submission. My lord, the major thing is, my lord, if the petitioner is not ineligible for the application of the examination, my lord,
that
her application should have been rejected.
No, that we will decide in this writ petition whether or not. You cannot decide.
No, it's just my submission before your lordships that if at all the application should have been rejected, should be rejected at the preliminary stage, my lords. Now after allowing the petitioner, she has qualified for the written
mistake
examination.
has been committed, it should be allowed to be perpetuated, and she should be appointed also, because she has been allowed to appear in preliminary examination. Therefore, she should be allowed to appear in main, and she should be appointed also.
No, my lord, the only grievance here is, my lords, she falls within the 3 years prior to 3 years category, my lords, and here she is not even the graduate. So according to the Honorable Supreme Court judgment, my lord, she is eligible for the examination. That is what my contention is.
You don't understand. You don't understand what can be done. We are not making here to, since you are not interested in an interaction, we did not say anything. You argue, we will decide. We were trying to tell you what is the point. You refuse to listen. And henceforth, you are a young person. Always listen to the court. Otherwise, it will have a bearing on your order. All right. That's it. Anything else? Yes. In this writ petition, the petitioner inter alia has prayed for the following. is so anxious to argue your case. See, eventually what matters is what we decide, subject to 136. Therefore, we were wanting a healthy interaction. You were so much neck deep involved in the case, as if you are appearing, you are a candidate for civil judge examination. You are only an advocate. Take this opportunity to learn something new from this case, right? Yes, Mr.
I obtained instructions, will also prepare counter. The Lordship's kind permission may I pass on.
Say what counter? She had, yes, contention is that the bona fide certificate was submitted and yet she was declared ineligible on 26.
That is not submitted. That is not submitted. Lordships.
Have you filed counter?
Yes, it was just it was there. Just I'm passing.
So then you want to go through the counter?
I'll get it for Monday or Tuesday, Lordship.
Reply. Learned Mr. Rao, learned counsel. Yes. Yes. Is that repeal thing, right? Repeal of provision. MI Act.
Omission. Omission of the provision.
Omission. Yes.
Omission. Simple omission.
Yes.
It has been treated at par. And the Royal Law Corporation I have cited below, which has not been followed. And in addition to that,
what are your submissions, Mr.
Number one, the penalty levied is on the basis of section 6, subsection 3, clause B of FIR.
On the basis of section.
Omitted with effect from 15th October 2019. The show cause notice was issued in 2017.
Yes.
And the impugned order was passed on 4th January 2023. And that's the fact that.
What is the submission?
My submission is when this provision has been omitted, assumption of or continuing to hold jurisdiction is not permitted because the provision got obliterated. I have just given a
provision was omitted with effect from 15/10/99. Therefore,
this penalty, that is jurisdiction to levy penalty, was absent.
Yes.
It could not be continued, though it was omitted, though it was initiated in 2017. Even the pending proceedings got obliterated because the amending act.
For filing an appeal, you are required to deposit some amount or something.
Yes. In this case, it is 78 crore.
Whatever. You are required to deposit how much? 50%?
50% under section 90 of the FEMA.
Okay. Clear.
Of course, the appellate tribunal has discretion to, but then I am challenging on the issue that
we wanted to understand. Otherwise, anybody else would have, instead of getting into this, all this would have advised to avail of the remedy. That's right. Yes.
I'm obliged.
Second.
No, one more ground is all these appellants petitioners, there were ex-directors in the company, which was notice number 1, Vasai Steels and Private Limited. Now, the company had gone before NCLT under IBC, and the resolution plan was approved in the year 2018 itself. Consequently, all those which were not forming part of all dues or whatever actions, which were not forming part of the resolution, got extinguished under section 31(1) of IBC. And that is where I have relied on.
What is the date of resolution, this thing?
The resolution plan my lord,
Was
dated, that is at page 268,
dated.
and the order approving the resolution plan
No.
of NCLT 13th April 2018.
1 minute, 1 minute. This, it will come up before some other, this thing bench.
Oh,
Mark the presence list, the appeal before a bench in which one of us write his lordship's name, Justice Shravan.
submission.
Yes.
The due date for payment has gone. And therefore,
Nothing happens.
now I have been listed with all the knowledge.
Monday we will take it up. You place the file for orders, Mr. Reddy. It will come up on Monday in a different combination.
Obliged.
IA 1 of 23, right? What is IA?
That the petitioners,
No.
that the government of AP.
What state do you want?
The direction to give consent by the Millar state of Telangana. But after bifurcation of state of Andhra Pradesh, as per Reorganization Act.
So what have you challenged? We have admitted the petition.
Yes, they did not file any counter. They are not given consent. The state of AP sought consent from the state of Telangana. As well as 1 year back, they did not made any efforts.
Let them file counter. We are not in.
Similar matters are disposed of.
Where?
Last time kindly take.
You did not tell us last date of hearing. We would have disposed it off.
Yes.
Which page?
Page number 132.
132.
Where they delayed. The operative portion, page number 140.
So this is 136.
Yes. 136 starts.
No.
Yes.
132 exit at which 136.
Yes, 135 is the relevant thing. Para 13.
Para
13. This court has time and again expressed the purpose of bifurcation of composite state of Andhra Pradesh into the state of Andhra Pradesh and the state of Telangana was not to separate the spouses when there are specific guidelines framed by both the states providing interstate transfer of the employees in June cadre spouse grounds if was incumbent on the part of both the states in process of applications of interstate transfer expediently and not delay them unduly to the prejudice of the applicants. In the instant case, since no reason is given assigned for the delay in processing the application of the petitioner for in the interest.
No, but this thing, the counter affidavit was filed in this case.
Yes, that is Milad. That is the thing. Now we
understand.
We will
dispose it off on the next date if they don't file counter. We are fixing a date. Mr. Krishnaiah, learned counsel for the petitioner, submit that the controversy
Sorry for the interruption, my lord.
Item 10. This 17.
My lords, item 6
Seven.
to 11, my lords.
1 minute, madam. This is 17. You-
I find a counter on the mistakes.
this,
Regular in this.
I find a counter.
Counter special today, Johnson said, we take up hearing with counter.
ready, Mr. Prasad.
That's only one request I would make. Well, actually verified a mistake by my office. The documents which are supposed to be entered in the counter have not been ensured. The periods are honorable for. It's a verified mistake on the. Should I take it up on Monday, but I'm fine dealing with it. The GOs and the proceedings which have been.
You have prepared a synopsis, right?
Yes, madam.
Monday.
Monday.
Learned Mr. Harinder Prasad, learned special. After this 21 is finished, we will take, you mention. See, this is the effect of getting an order. See, this is on a mention memo. Mention memo. Yes. Nobody is appearing for petitioner.
My lord, my learned king is appearing for video virtual.
You mentioned this matter, right?
Yes.
It's urgent. What is urgent?
My lord, learned senior will.
Yeah, made please.
No, Mr. This matter was got listed, if you remember, on a mention memo.
Yes, my lord. And
What is, it's a public interest litigation, right?
yes, my lord. Your lordship said earlier occasion has directed to file an application, expedient application. Therefore, IA 1 of 20.
Okay, what is the subject matter?
Subject matter, my lord. This is a public interest application is filed by the petitioner, my lord, seeking to protect the hillock, my lord, because the respondent number 10, who is trying to convert the entire government land, which is a hillock, in survey number, my lord.
Pleadings are complete. Pleadings are complete.
Yes, completed from the both sides. Pleading.
Lord, mark the presence. Pleadings of the pleadings in the case are complete. Petition is admitted for hearing. Heard on IA number.
Mr. P. Govind Reddy.
All right.
Grateful.
Yes.
May it please, my lord. The writ petitioner is the appellant.
What? Let her call the number. We don't have the file also. She has not called. Yes. 22. Called respondents with presence also, they are not appearing. They may not be aware.
Your lordships, I am appearing, my lords.
Oh, yes.
My lord, last time I had given a list of dates, my lord.
What is it? What? Date of birth. Date of birth issue, right?
No. My lord, this relate, the grievance of the petitioner is more failure to promote him on the basis of adverse remarks which had not been communicated to him. Well, the petitioner was an employee of the State Bank of India. Throughout, my lord,
Let us go through.
very
the-
well, very well.
It will save time.
My lord.
That's the purpose. Dev Dutt covers the point.
Yes.
2008. Provided it is so. Dev C.
రెండు ఇవ్వాలి. ఇద్దరు జడ్జిలు ఉండాలి. రెండేంటి తర్వాత నెక్స్ట్ చేద్దాం వరుసగా. Pension First hearing.
So why petition has been dismissed?
Well, what the learned judge said, he relied upon Jalanagam case, saying that a downgrading per se would not, my lord, be treated as adverse. And therefore, my lord, your lordship will find the reasoning from page 21 onwards of the order and IP. Please see, my lord, 21 bottom. May I read, my lords? Learned counsel with the petitioner relies upon several
Give us
judgments.
1 minute. So UP Jal Nigam has been otherwise overruled.
Yes, my lord.
We've seen.
Overruled, it's been overruled. Learned judge places reliance.
Page 21.
Yeah, 21, my lord, please see the contention. My lord, in the first para, learned standing counsel respondent bank, 3K so-and-so, on instruction submits that any representation of the matter should, including against adverse downgrading entries made in his performance appraisal for the years 99, 2000 by third respondent, would be considered carefully and diligently by grievance thing. And at the bottom, my lord, learned counsel of petition relies on several other judgments, including so-and-so, unreported judgment, so-and-so. Then, my lord, at page 22, that contending that confidential reports are not casual documents, but are important instruments for appraisal of the performance and public service, that adverse entries must be communicated, and that uncommunicated entries ought not to be considered for denying promotion. Some of the judgments cited by the learned counsel pertain to adverse entries in relation to cases of compulsory retirement of employees. It is well settled that in a case of compulsory retirement, even an uncommunicated entry could be taken into consideration. Though in matters of promotion to selection posts, uncommunicated adverse entries cannot be taken into consideration, there appears to be no established current principle that downgrading of an entry from outstanding to say very good should necessarily be communicated to the employee. Indication of such fall in the standard of an employee may be salutary practice which conduces. So this is how a learned judge non-suited my client. My lord, now all the judgments I'm relying upon, I'll pass on, my lord, and just indicate the paragraphs.
That you have mentioned here.
Yes, I've extracted. I'll also give copies.
Yes, madam.
Your lordships, the petitioner superannuated from the service, my lord, and at what stage he was retired from the service, we are not aware. He retired 4 years back, my lord. If your lordships permit me,
Madam, he may have superannuated, but he will be entitled to consequential benefits. You have to consider his case without taking into account the uncommunicated entries.
It has been communicated, my lord. Your lordships might kindly take it up on Wednesday. I will produce.
No. This is not like the Wednesday and Thursday. This is the day.
Your lordships, because my lord, the original record is with the bank, because the matter pertains to Andhra Pradesh, my lord, we have to get it because the respondents are there.
It may pertain to Himachal Pradesh. That doesn't matter, madam. Yes.
Your lordships might kindly have it on Tuesday, my lords.
No. Madam, the council was arguing and we were going through. You did not say in the beginning that I want time. And once it has been already granted. No. This is not a lecture going on, madam. The 12/9/2023 also you appeared through video conferencing, sought adjournment, we have adjourned it. Again, what is like this thing every day? Why it should be adjourned? No adjournment, madam. We are this thing we are allowing the appeal. Yes.
May kindly pass it over, my lord, and get the instructions.
No question of passing over. This is appeal, madam. This is appeal pending for 15 years. And when we have heard the counsel for other side, This is not a ground that now I will seek instruction. You should have thought instruction. 15 years, what were you doing?
It was communicated to them, my lord. I will ascertain in instructions.
No,
my
no,
lord,
no.
what stage. Whether rule provides your lordships may kindly at 2:30,
Sure.
my lord, submit before the court.
This is not the ground on which he has been non-suited. He has been, where is the finding recorded by learned single judge that the entries for the year 98, 99 were communicated to him?
Your lordships may kindly.
That is the specific case. Show which paragraph, where have you said in your counter that it was communicated?
Yes. Your lordships may kindly see the counter, my lord.
Anywhere, Mr. You tell as an officer of the court. What is it their case? No, because he doesn't know, right? These people are engaged by the bank. What to do? Yes, you tell us which paragraph is there. Stand.
Counter filed by the second respondent at
Page.
Personally, he may.
Page
83.
83. Okay. We will ourselves see, because we have to do justice, right? She has not taken note to do justice even to her client also.
My lord, your
Fine.
lordships may
Sorry.
kindly see, my lord.
Nowhere, my lord, it stated it's communicated.
That one.
85, my lord, page number 85.
Nowhere it stated it's communicated. Judgment
Which
stated on the basis.
she is pointing out para 85, page 85. Which para, madam?
Subparagraph I, my lord, the procedure contemplated for communicating the performance appraisals report. Annual appraisals reports form AARF as per the extent instructions. Annual appraisal report form has to
No,
be.
it doesn't. Madam, para A, B and I is something annual. There is no procedure which something else you are reading.
As per the procedure, my lord, we have followed and considered his case. Your lordship may kindly see the procedure for a minute, my lord. Annual appraisals report as per the extent instructions. Annual appraisals report form has to be complied on all officers in the banks on 31st March every year. The report will be complied by the immediate controlling authority. The bank has introduced the system of review and appraisal of the AARF to ensure the objectivity of reporting accordingly. All AARFs, though complied, have to be reviewed by an authority who should be at least one grade above that of the reporting authority. Thereafter, such reports are to be approved by the general manager, chief general manager of circle of officer up to middle management grade scale 3 will be approved by the general manager, and that the senior management grade scale 4 and above the chief general manager who while doing so will objectively and independently assess the AARFs and may retain, increase or decrease the ratings basing on their independent assessment of the performance of the officers to the present year as also as past 3 years performance. Traits and other things, my lord. The counter, it is the counter, my lord, filed by the reporting officer. It is the counter filed by the reporting officer, my lord. Counter filed by the. Your lordships may kindly see, my lord. Your lordships.
No, Mr. One thing. Where is this admission that the reports were adverse? Or like, I mean, this is your assumption that
The entire case was on the basis, my lord, of adverse remarks not being communicated.
where are those adverse remarks?
Adverse remarks, my lords will find, my lord, at pages from 145 onwards.
140.
My lord, they filed along with the counter.
That's what we wanted to know. 145.
Yes.
What is adverse remark?
My lord, 145, your lordship will be pleased to see at the bottom, my lord, earlier ratings of the year 96, 97, 98. At the bottom in a tabular form are all, my lord, 100, 94, 100. Only for 2 years. So please see, my lord, at page,
No, 96 and 98 it was 100, 97 it was 94.
yes, only my lord 97, 98, he had a low, my lord, rating by the third respondent because he made some allegations against him. Learned judge, my lord, said, we were not able to, my lord, substantiate the same, notwithstanding the fact we filed the complaint and a report of an investigating agency as regards the proposals. Now, my lord, as far as his adverse remarks, my lord, they've been filed along with the counter.
Now, which page?
145, my lord, please see. 145. 143 onwards.
Yes.
My lord, please see 143. Housekeeping, always in arrears.
No, it is for a period from what period?
This is, my lord, for the period.
From?
It's a period, 140. 98, 99.
Page, it begins at page 143 only, right?
Yes. All the, my lord, from 140 it begins.
143.
Then 143, my lord, are all the adverse entries.
See, housekeeping always in arrears then?
Then, my lord, complaints are dealt with in abnormal delay after
several
reminders. Then, my lord, several reminders are required. Correspondence is casual, does not carry the recommendations of the branch managers. It is most of the time mere post office business, not very comprehensive, needs guidance. The follow-up of the credit is poor, needs proper follow-up, satisfactory but leans heavily on controlling authority for support. Then, my lord, 144 also. Lord, upon
that we saw only, we saw 144 only.
Yes.
No, there are two numbers. What?
My lord, please the
pencil or pen? Which number you are referring to?
My lord,
There is
144 in
it is
pen,
struck
lord.
out with and written with pencil. Which number?
My lord, 144 written in
I think
dark
yes.
ink.
144 with ink. Yes.
That's
what you
continuation,
read.
my lord.
Yes. What else?
This is, my lord, he ends there. And grading, please see at 145, we give 72.
72.
At the bottom, my lord, Sri Anand Prasad is an official having knowledge of bank working rules regularity.
No,
He
where,
leaves
where?
Bottom, my lord, handwritten thing after the tabular form. General comments. At page 144. 144, my lord, general comments.
Where?
See, Anand Prasad is an official having knowledge of bank work, rules and regulations. He leans too much on controllers for everything and passes the buck. He does not take even the fair.
It is like this first, then this.
You,
Yes.
Your lordships might kindly see the page number 145, my lord, for a minute.
1 minute, madam.
144 at the bottom, my lord.
We will hear you. You get ready in the meanwhile. Yes.
144 at the bottom, general comments.
Yes.
Sri Anand Prasad is an official having knowledge of bank work, rules and regulations.
All right.
He leans too much on controllers for everything, passes the buck. He does not take even the fair banking risk. He is satisfied with routine work in a routine manner. He may be tried in positions which do not contain budgetary responsibilities, preferably in zonal office. Then, my lord, 145, he gives a total of 72, which is, my lord, which would come to satisfactory. Requirement is, my lord, 4 years. It should be outstanding or very good. Then he
Where
gets
is the requirement?
My lord, at page 41 are the regulations. My lord, they take 3 times the number of vacancies. And on the basis, my lord, the grading is given.
41.
41 is the, my lord, promotion policy, which was filed by the respondents in there, along with the counter, which we have included.
Where is it?
Page 41, my lord.
No.
Your lordship will see promotion from scale 3 to SMG scale 4 and from scale 4 to scale 5. We are concerned with promotion from 4 to 5. Eligibility criteria.
5.4.
Yes, 4 to 5. Please see, my lord, eligibility criteria, small Roman number 2. Promotions to SMGS week 5. Minimum 4 years service as officer and so and so. Then, my lord, zonal consideration. All officers who fulfill service eligibility criteria for promotion to.
You are in zone of consideration, right?
Everybody, my lord, about 3 times the number of vacancies are taken and then selection is made. Unless the competition so is intense, unless, my lord, they get outstanding for 4 years, they will not be selected.
Yes.
Now, my lord, your lordship sees his case was earlier on. It was good and very good and outstanding. Only 2 years, my lord, when he was in, my lord, Mangalgiri branch. My lord, the immediate supervising authority was compelling him, my lord, to sanction a particular loan. My lord, the appellant before your lordship had some doubts about it. And therefore, he was constantly pressurizing him. He also threatened to, my lord,
So your ACRs for which period were to be taken into account?
my lord, 4 years from 99. I'll just tell my list of dates. 98, 99, where is my list of dates? I'll just tell you, lordship. 4 years are, my lord. 98, 99, 99, 2000.
Where is the guideline of 4 years?
4 years is, my lord, as 41, 4 years of service. At page 41.
4 years. So,
those 4 years rating ACR will be taken.
90?
My lord, my client's case, as I pointed out, my lord, in my material papers, in the list of dates at column 10, 99, 98, 99, 99, 2000, 2000, 2001, 2001, 2002. 98, 99, my lord, he got only good. 99, 2000 also, he got good. 2000, 2001, excellent. 2001, 2002, excellent. Therefore, my lord, he gets eliminated. Competition is very intense.
No, 98, 99 is good.
Good.
99, 2000 is good.
Good.
And 2000, 2001 is excellent.
Yes, that is after he got transferred to Visakhapatnam branch. The crucial period, my lord, is 98, 99, 99, 2000, when he was in Mangalgiri branch.
So this thing is that this you have shown us.
Not communicated.
98, 99 was not communicated.
99, 2000 also not communicated.
No, where is 98, 99 is 144.
Yes.
Where is 99, 2000?
My lord, 99, 2000 at page 150. Actually begins, my lord, at
149.
149.
All right. Yes, we have got it. And in the counter, there is this thing, there is nowhere it is said that these have been communicated.
Yes, there is no denial of that. The entire case proceeded on that basis.
That you have not been found suitable, right?
Yes. But your lordship will be pleased to see what the learned judge, as your lordship has noticed, he says this granting you good can't be treated as adverse.
Where?
At page, my lord, 22, learned judge says that it's not adverse. And he relies upon Jal Nigam, my lord. So, page 22, my lord. About the middle, though in matters of promotion to selection posts, my lord.
No, page
22, my lord, of the judge.
Though in matters.
Yes. Though in matters of promotion to selection posts, uncommunicated adverse entries cannot be taken into consideration. There appears no established current principle that downgrading of an entry from outstanding to say very good should necessarily be communicated to the employee. Indication of such fall in the standard of an employee may be salutary practice which conduces administrative efficiency, but that is a different from holding that non-communication of such downgrading vitiates the very selection As pointed out with Supreme Court in UP Jal Nigam, if there be reasons recorded for downgrading of performance appraisal or of an officer vis-a-vis previous years, that would be sufficient safeguard. In the case on hand,
All right. Yes. This month, this, yes, he's been turned down on this round, which we tell you. In this law, that freedom is over. Yes, madam.
Your lordships may kindly see the page number
Your
140.
submissions first. What are your submission? As per procedure, his case was considered, not considered.
His case was considered, he was within the zone of consideration, but he did not reach the benchmark. And there are no adverse remarks, my lord. It is only a general observation by the reporting officer. Your lordships may kindly see the page number 144 for a minute, my lord. Your lordships, page number 144.
Oh, this is a case where you are saying that your employee is very good and not proper. He is saying I am bad. Yes, 140.
4, my lords.
Yes, madam.
And 145 is the table reporting authority has given key responsibility areas 25. Again, it went before reviewing authority 30 marks. It has enhanced. Standing review committee 30 marks. It has been reviewed by 2 other authorities who are empowered to review the reporting officer's assessment. That is the reason why, my lord, there is no question of downgrading or giving any adverse remarks to the petitioner. And one more thing, my lords, here his particular case is because he did not follow the instructions of the third respondent with regard to the sanction of floor.
No. Madam, we are not going into that question. Neither the counsel for appellant has argued that because that finding is against him by learned single judge. He has not even urged. The only thing is we have to decide whether his remarks as per his contention is adverse and it should have been communicated. You are saying it's not adverse. There was no need to convey those remarks.
Your lordships may kindly see the learned single judge's order, madam.
So there was no need to convey those remarks according to you.
Because these are not adverse remarks, my lord, cannot be.
Fine. Yes, that's it, madam. Anything else?
Your lordships, I will read one sentence from the learned single judge's order, ma'am.
Please read.
Your lordships, page number 22 of the spiral binding, madam.
Yes.
Civil appeal number 868 of 2000 arising out of SLP 23839 of 2005 for contending that the confidential reports are not casual documents but are important instruments for appraisal of the performance in public service. The adverse entries must be communicated and that in uncommunicated entries ought not to be considered by denying promotion. Some of the judgments cited by the Land Council pertain to the adverse entries in relation to cases compulsory retirement of employees. It is well settled that in the cases of compulsory retirement, even an uncommunicated entry could be taken into consideration. Though in the matters of promotion to selection post, uncommunicated adverse entries cannot be so taken into consideration. There appears no established current principle that the downgrading of any entry from outstanding to say very good should necessarily be communicated to the employee. Indications of such fall in the standard of an employee may be a salutary practice which conduces administrative efficiency, but that is different from holding that non-communication of such downgrading vitiate the very selection. Again, my lord, this is UP Jal Nigam. In the next paragraph, my lord, I may be In the above circumstances, this court is not inclined to grant the petitioner to relief in species as it thought in the writ petition. No mandamus can issue to promote the petitioner to SMGS 5. Admittedly, a selection court that it is an assessment that must normatively remain with the first respondent. The petitioner, however, has at liberty to submit representation to the second respondent within 15 days regarding the grievance pertaining to the non-promotion of SMGS 5, including his performance appraisal during the year 99 and 2000. The respondent number 1 and 2 shall consistent with the undertaking given to this court at the hearing. Please place the petitioner's representation grievance before the grievance redressal committee within a week from the date of receipt of the petitioner's representation, and the grievance redressal committee shall consider the petitioner grievance and take a reasoned decision therein, which shall be communicated to the petitioner expeditiously in any event within a period of 3 months from the date of receipt of the order.
Yes. Anything else?
But that's all, my lord. No other.
Yes. Now, please ask, Mr. if any difficulty, right? Don't leave. in so and so, what have you written, Mr. Reed? In Sukhdev Singh versus Union of India. Ah, delete. Supreme Court, Honorable Supreme Court is Sukhdev Singh versus Union of India, so and so. Thereafter.
One prayer, my lord.
Yes, madam.
Your lordships, if it is uncommunicated, adverse entries is not communicated to him, my lord, giving liberty to him to communicate, my lord. Your lordships may kindly observe that one also.
That vitiates, madam.
That's
You have not communicated. He has been required to rush to the court. The
communication. Your
don't
lordship may
read,
kindly
madam.
give Your lordship may kindly give liberty to communicate.
We have considered your submission, rejected it. It is to be communicated within reasonable time, not when writ appeal is allowed. Yes.
Your lordship, because the
Rejected.
judgment rendered.
No, madam, please keep some grounds alive for 136 also. We know that you are a chronic litigant. You will not accept this judgment. You will go, you be ready, mister, for another round of litigation in Delhi.
No, my
State
lord,
Bank,
not that one.
State Bank
That is
will
not
not
that
accept.
kind, my lord. When your lordship is directed to consider, we won't do it, my lord. We will prospective
Therefore, you have a, madam, this is said in lighter vein. You have a constitutional right. How can we deprive you of your constitutional right?
No, you much obliged.
Fine. This has to be considered within reasonable time. So how can now we will say that you now yes, Mr.
Last this matter came on laying on a judgment, my lord.
Huh?
Laying on a judgment of this Honorable High Court, my lord.
Judgment?
23 1 ALD of 83.
No, full bench decision of this thing. 2023 one.
Yes, my lord. Yes, my lord. The full bench matter is covered, my lord, by the decision of this honorable court.
What is the issue in what?
Lordship may kindly see, the issue was before the full bench was there were two differing judgments. My lord, I have passed on the judgment copies. May I once again pass on, my lord? 2023 1 ALD page 83, my lord.
No, correct, but what are the facts? You will have to write at least something. Have you prepared a synopsis?
My lord, I have prepared a small short.
Yes, please.
I'll pass on. Kindly.
Once adjournment has been granted, now no more adjournment. It is our case, 15 years it is pending, right? You are not in a hurry. You want the appellant to die.
No,
waiting for his death. That's why he has already died. So you are seeking adjournment to see that his LRs also die, right? We don't want.
My lord, against this order, Supreme Court has already given status quo is there, my lord, to an SLP against the order of 2021 83.
My learned friend is saying, my lord, that against the full bench judgment passed by this honorable court, the aggrieved party has approached honorable Supreme Court and he has filed the honorable Supreme Court's order along with him.
But all laid down. Inter-parties.
Supreme Court only said
inter-parties, and apart from sitting in division bench, the law laid down by full bench binds us. Simple. Where is that order?
My lord, I filed a memo, my lord.
Where is it? Give the memo, right? That is your only case.
He has served another memo. Yes,
91932 of 2020. Yes, sir.
You write further. You write this very hard. Get into the practice. This all is given here.
Honorable Supreme Court's order.
One.
Para 7 was that two different opinions.
Where are those judgments? We
No,
did
no, I
not
am-
even refer to facts, etc.
Well, not.
Fine.
Well,
No, no, we wanted what is the conflict in opinion and this thing, right?
Lordship, may I
Yes,
pass on?
yes.
May I pass on that full bench judgment?
Ah,
Full bench refers to the conflicting opinion.
what is it?
Lordship, in fact, para 58, end of the judgment, the lordships have clarified. Para 58, my lord, end of the judgment, last page. In the light of above discussion, we answer the reference as under. The law laid down in Veera
No,
Reddy.
what is this? This what we want to know. What is Veera Reddy and this Reddy?
My lord, this is what, I'll just explain, my lord. One view was as
The citation we want. Citation Veera Reddy's Supra means what Supra?
at page 2, my lord.
Conflicting opinion was
My lord, the conflicting opinion was
between Veera Reddy and
Ramendra Reddy. Those are the things, my lord.
Ramendra Reddy.
Yes, my lord. B. Ramendra Reddy. That is 1993 to Indira Weekly Reporter, page 84.
Yes. Ramendra Reddy and others versus District Collector Hyderabad.
Yes.
And other is Veera Reddy and others versus Chettapalli Chandra.
Yes, my lord. That is 1994 SCC online AP 510.
All right. Yes.
So they upheld Ramendra Reddy's.
This intra-court appeal is filed against an order dated 23rd September 2008 passed by Do it just now. Give it to him, madam. Yes.
Grateful, madam.
I don't know, we are permitting consent, not supposed to do. Who decides what happens in the court? This court decides, right? Division bench is permitting. He will go and never carry out correction. You give him. Yes, Mr.
We are appearing for the respond number 4 law. It seems that the council on record, he has died no more. Take over than Reddy.
Oh.
Take over than the appellant.
This notice has been issued, right, on served.
Notice.
None for the appellant, a statement. None for the appellant, Mr.
I'm Ashok Raj.
Ashok?
Fourth respondent. Why Ashok Raj?
Whatever, write his name for respond number 4. On 19/7/2022, a statement was made.
Kindly request your lordship to take up this matter on Monday.
No, argue. Yes, please go ahead.
I'm requesting senior Millard. Senior is not.
No, senior, we are not granted adjournment in any case. Array, Mr. Monday, things will be different, right? We will have a look at it. What is it? 2009. Nothing.
So I'm appearing for the unofficial respondent. I'll prepare a brief synopsis.
Great. It doesn't look to be brief, running into how many pages?
Brief synopsis or citations to that. Allow with citations.
We were frightened like this is brief is synopsis, then we don't know what is.
provisions of law that arise for consideration.
1 minute. We are going through it. He is the appellant. You want to say anything? Please argue. 1 minute. Let us go through this synopsis and then you can argue.
I would only request me to
No request.
an accommodation to Monday,
No,
today to Monday
no,
only I am requesting. A senior is not.
No, we have, Mr. We are not granting adjournment in any case. We cannot make an exception in your case, right? This thing, the working Saturday is for advocates also, not for only judges, right?
No, that which is not available, Bilal.
Yes. Which council you have to pay it to? What are you submitting?
My request is for.
No. Go ahead, Jen. We are asking for submissions, not that you have said thrice. We have declined. What can you do? You can't do anything better. Any submissions, if you are required to, otherwise we will advert to, we will take that grounds of appeal are your submissions, right? Whatever you have mentioned in grounds of appeal. Are you, at least read those grounds if you want to read.
Yes.
Otherwise we take it contrary to law vitiated by error of facts and law. First ground.
But writ petition was filed by the respondent herein, my lord, challenging the order passed by the joint.
We want to tell you, Mr. We have more faith in your capabilities than you yourself has. We know that you can argue this appeal.
But this is the writ petition, my lord, that is argued by senior.
Therefore, no, you can argue. The senior hasn't come. The court is not granting adjournment. Please argue. We know that you can argue. You have argued several matters before us. Please go ahead.
But this matter has not been fully prepared by me to be.
Whatever argue, prepared. Whatever is preparation. Today is the last day of this case in the High Court. Yes.
The writ petition is filed by the respondent for this honorable court, challenging the orders passed by the joint collector, remanding the matter to the Mandal Revenue Officer, and after remand, the order of the joint collector was not challenged. He participated in the proceedings that have been proceeded before the Mandal Revenue Officer. After the order is passed against him, after the entertaining of the application filed by the writ petitioner as a revision under section 9, joint collector, he has not chosen to appear despite service of notice and participated in the proceedings before the Mandal Revenue Officer. And therefore, the order remanding the matter to the Mandal Revenue Officer worked out itself, and when the order is adverse to him, he challenged the order of joint collector on the ground that he was not issued with any notice
So he has accepted the order of remand. This is the submission, right?
Yes.
Because he has not challenged it.
He has not challenged the order of remand.
Yes.
He has accepted it, and after an order is passed adverse to him, he challenged that order before this honorable court on the ground that he is not served with notice.
Yes. Correct.
And that there is a delay. And so far as the aspect of notice is concerned, it has come to this honorable court with by not presenting the true facts, and therefore this honorable court has called for the record of the joint collector and verified the record and found that they were served with notice. 4 of them were served with notice.
Yes.
And 2 of them are also served with notice by way of a substituted service. And your lordship would find that those findings by the learned single judge at page 37, Miller.
37. Yes, please.
It is noticed in the affidavit, my third paragraph, unnumbered third paragraph. It is noticed in the affidavit filed in support of the writ petition. The petitioners contended that no notice was given to Gopal Reddy and Siddha Reddy or the petitioners about the reopening of the case before the Joint Collector Rangareddy district. In view of this submission, the records pertaining to the revision were called for. It is found that the Mandal Revenue Officer Gatkeser addressed a letter dated 8/2/1999 to the collector, Rangareddy, stating to the effect that the copy was served of the notice was enclosed therewith. It was further stated that Indrasena Reddy, K. Ram Reddy and Pratap Reddy were not residing in the village and that their addresses particulars were not known. Along with the said letter, a signed copy of the notice dated 29/1/1999 is found. Therein it is stated, please take notice that the above case is posted for hearing on so and so for the joint collector. Therefore, you are required to be present before this court either in person or through an advocate and set date, time, so and so, material on record. The above notice was issued in the case between K. Jaipal Reddy and Gopal Reddy died per LR and K. Siddha Reddy died per LRs. The notice was addressed to K. Pratap Reddy, L. Sudhakar Reddy, K. Ravinder Reddy and K. Upendra Reddy as LRs of K. Gopal Reddy and to K. Indrasena Reddy, K. Ram Reddy, K. Lakshma Reddy as LRs of K. Siddha Reddy. On the rear of this notice, 4 signatures are found in proof of receipt of the notice dated 2/2/1999 and it is endorsed thereunder that the remaining persons were not residing in Gatkesar village. This endorsement is made by the Mandal Revenue Inspector under his signature dated 5/2/1999. The above notice is said to have been served upon K. Siddha Reddy, Ravinder Reddy, Upendra Reddy and Lakshma Reddy, 4 out of 6 persons herein. Insofar as the failure of service of notice upon the other 2 petitioners is concerned, it appears that the respondent 3 moved an application before the Joint Collector Rangareddy district seeking to cause substituted service of notice and the same was permitted by order dated 8/4/2000. In pursuance thereof, publication of notice was caused in Inadu Telugu paper Rangareddy edition dated 8/4/2000. The original newspaper evidencing this publication is also available in record and shows K. Pratap Reddy, Sudhakar Reddy, Ravinder Reddy and Upendra Reddy being sons of late Gopal Reddy and K. Indrasena Reddy, Ram Reddy, Lakshma Reddy being the sons of late Siddha Reddy were put on notice that a petition had been filed by respondent number 3 herein for rectification of the record of rights against K. Gopal Reddy and K. Siddha Reddy and that they were required to be present in person or through advocate on the next date of hearing of the case fixed on 17/4/2000. In view of the above facts, which emerge from the original records, it is quite clear that it is not open to the petitioner to allege any procedural lapse or irregularity in the service of notice insofar as the proceedings before the Joint Collector are concerned. But these findings of fact recorded by the learned single judge, but after calling for the record and after verification, but have not been disputed and not been challenged by the respondents. There is no evidence on record to show that the petitioners ever raised any contention with regard to alleged delay. This is so far as the delay is concerned. In the exercise of the revisional power by the Joint Collector Rangareddy, no such ground was raised before the Mandal Revenue Officer Gatkesar Mandal. Without a foundation, it is not open to the petitioner to raise this issue for the very first time in this writ petition. This aspect is therefore eschewed from the present adjudication. On an analysis of the material on record, following matrices emerges. Initially, the grandfather of respondent number 3, Jagga Reddy, filed an application under section 15(2) of the regulation 1358 firstly, being an aggrieved person. This is so far as an application that was originally filed in the year 1960s itself by the grandfather Jagga Reddy. Under the then regulations 15(2) of the 1358. But for rectification of the entries in the Pahani, because the Pahani is the entries in the Pahanis were illegally made, but taking advantage of the relative of the respondent as a patwari in the village. But that is also found in the other record of the collector of 1963. And that is the initiation point of time, Millard, challenging the entries in the Pahani. And thereafter, Millard, in the year 1969, he died. And his son also died. And the third respondent in the writ petition, Millard, has filed the application under 15(2), Millard, in the year 1988, Millard. So far as the respondent number 3 is concerned. But the 2 grounds which they have raised, that the service is not affected when the matter is pending before the joint collector is found to be false, and the delay which they raised also is rejected by the learned single judge, and the other ground, namely the respondents have filed a suit for partition, that is OS number 348 of 1989. But when my application that was filed by the appellant was pending before the DRO, they have filed a response stating that we have filed a suit for partition. But under the ROR Act, when there is a suit that is pending, that the revenue authorities would await the decision of the suit. Therefore, my application was closed, recording that there is a suit pending. But this suit was dismissed for default on 7/8/1996. That your lordship would find page 41, my lord, internal page 30 of the judgment. The suit in OS number was dismissed for default on 7/8/1996. Thereupon, respondent filed a petition also seeking to reopening of the case under 15(2) and rectifying the wrong entries in the record. You lordship, page 41, minute.
Yes, yes.
To rectify the wrong entries as per the area of the respondent shown in the said petition, Gopal Reddy and Siddha Reddy, the predecessor and title of the petitioner, were shown to have died and were represented by their legal representatives, the petitioners, and respondent number 4 herein. It appears that this application was taken on file under section 9 of the Act by the Joint Collector. Whether said action of the Joint Collector in treating an application seeking reopening of repealed as 1 under 1971 is proper and correct would have to be ascertained from the scheme of the Act. An examination of the scheme of the Act 1971 and rules framed thereunder would show that this Act, as compared to the other revenue laws such as AP Telangana Land Revenue Act, stands on a different footing altogether. Section 3A of the Act gives its overriding effect over the provisions of the Telangana Area Land Revenue Act 1317 firstly. The argument of the learned counsel for the petitioner that to the contrary, therefore, does not hold water and is liable to be recorded. Even this contention is also was rejected by the learned single judge. Under the normal revenue laws of mutation, is effected for the purpose of achieving the physical objective, that is collection of the land revenue from the person in occupation. The entries made in the records under such laws do not confer title and are merely indicative of possession. However, the Act of 1971, having undergone several amendments, enjoys a unique status as compared to the other revenue laws, inasmuch as it attaches certain presumption in respect to the title to the revenue records maintained thereunder. This aspect is demonstrated by Section 6 and 6A of the Act 1971. Under Section 6 of the Act 1971, every entry in the record of right shall be presumed to be true until the contrary is proved or until it is otherwise amended in accordance with the provisions of the Act. Under Section 6A of the Act of 1971, every owner patadar is required to apply for issuance of a title deed and passbook under the provisions of 1971 Act. Even if such application is not made, Under Revenue Officer is authorized suo motu to issue passbook after collecting the fee prescribed thereunder. The section provides that issuance of a title deed and passbook is to be on the basis of the record of rights which has been brought up to date. Under Section 6A5, it is laid down that the title deed issued under Section 6A1 shall be the title deed in respect of a owner patara, and it shall have the same evidentiary value with regard to the title for the purpose of creation of equitable mortgage under the provisions of Transfer of Property Act 1982 as a document registered in accordance with the provisions of the Registration Act 1908 as under the law. In the light of the value and importance which attach to the records of right maintained under 1971, it would be necessary to insist on strict maintenance of such record, according to which in accordance with the provisions of the Act and the rules. It is only when such record is kept in conformity with the requirements prescribed by the Act 1971 and rules of 1989. The presumptions enjoined under Section 6(a) would arise and inure to the benefit of the holder of such rights. The rules of 1989, framed under the Act of 1971, detail the procedure to be followed by the revenue authorities in the course of preparation of record of rights as envisaged by the Act. The scheme of the said Act clearly indicates that the revenue authorities are required to hold a summary inquiry into issues of title also in certain circumstances by deciding the dispute as to the entries to be incorporated in the record of rights. The decision of the learned division bench of this court in Singamani and Pullamas is also to that effect. However, this authorization to the revenue authorities is subject to the judicial determination of disputes over the issues of title as demonstrated by Rule 9(1)(c)(2). Here in the case on hand, the respondents herein have filed a suit for partition, namely OS number 348 of 1989 for resolution of their right, and which was dismissed for default. But your lordship knows, my lord, under Order 9, Rule 9 of the CPC, but once a suit is dismissed for default,
cause of action bars the same.
And they are debarred from filing a suit on the same cause of action, and they have not taken any steps on dismissal of the suit filed by them for determination of their rights, retained finally, and they have lost it, and there is an adjudication. But the one contention that they have raised is that it is not a decision on merits; it is only a dismiss for default. It does not bind us. But that is contrary to the law laid down by the Honorable Supreme Court, and their determination ended in dismissal. Now, so far as the present application is concerned, one ground, that is there is no service, that is found to be contrary to the record, and the delay which they have not taken up, and that also is rejected by the learned judge, and the one that their rights are to be determined, so far as that is concerned, that they have availed it, and that is also dismissed. And in the present case, my lord, the Mandal Revenue Officer has recorded, those findings are also recorded, my lord, that your lordship, I may read this and take your lordship to the other. Once a declaration is filed by a party that has instituted a suit, this is 9(1)(c)(3). Once a declaration is filed by the party that has instituted a suit in a civil court to establish its title, revenue authority is required to await the result of such suit before taking up further action. This rule makes it clear that even in cases involving dispute as to the succession to the property of the deceased registered holder, the Mandal Revenue Officer, in exercise of his powers under this rule, is required to hold a summary inquiry and decide it as to who has the right to succeed to such property by applying the law of succession governing the case. But in this case, what the revenue authorities did is, when he has filed a declaration before them that a suit is filed, he closed the proceeding stating that await the result of the suit because suit is already there. But after suit is dismissed and this is reopened and the adjudication is taken further. The decisions and so on so relied upon by the Revenue Council for the petitioner, stating to the effect that the revenue authorities cannot decide the questions of title were rendered in the environment of the general revenue laws, which stand on a different footing when compared to the Act of 1971. This contention that the revenue authorities cannot go into the question of title is also rejected by the learned single judge, because the scheme of the Act is as discussed in the earlier paragraph. In the light of the scheme of the Act, it cannot be said that the record of rights maintained thereunder are only for the purpose of achieving a physical objective, as is the case with the other revenue laws of this nature. The judgments relied upon, therefore, have no application to the facts of the present case. It is However, to be noted that revenue authorities are not substitute for the courts of competent civil jurisdiction, and it is for the party concerned to invoke such jurisdiction so as to bar the summary inquiry by the revenue authorities into issues of title in the peculiar given circumstances. Needless to state, revenue authorities in such a summary inquiry would not be capable of deciding complicated questions of title. The scope of circumstance of such inquiry by the revenue authorities is circumscribed by Section 5 of the Act, read with Rule 9.1 to 9.1A to 9.1.3. And but after extracting the Rule 9.1A to 9.3, but the scheme of the Act was extracted by the learned single judge, and these then are the only dispute that can be resolved by the Mandal Revenue Officer in the next page, which the learned judge has recorded. The above provisions demonstrate that the revenue authorities under the Act and the rules are empowered to undertake a summary appraisal and inquiry of a particular dispute in respect of title. Such inquiry is obviously not a substitute for an adjudication by a civil court of competent jurisdiction. In the course of such inquiry, it would not be open to the revenue authority to set aside the transactions or adjudicate the complicated issues falling outside the scope of the rules 9.1A to 9.1.3 of the Act. But so far as the facts of the case are concerned, they have been extracted. Coming to the facts of the present case, it is noticed that under Section 3.1 of the Act, after the commencement of the Act, in any area, the recording authority is required to prepare and bring up to date from time to time the record of rights of all the lands in every village in that area. Under Section 3.2 of the Act 1971, after preparation of the record of rights under Section 3.1, the fact of such completion is required to be notified in the AP Gazette or the District Gazette. Under Section 3.3 of the Act 1971, any person affected by an entry in such record of right is permitted within a period of 1 year from the date of notification caused under Section 3.2 of the Act to apply for rectification of the entry. The officer to whom such an application is made is required to give a decision on the said application after such inquiry and direct rectification of the record of rights in accordance with such decision. The said decision, subject to the revision under Section 9 of the 1971, attain finality. There is no evidence on record as to whether and when any steps were taken under Section 3.1, 3.2 of the Act 1971 in the area covering the subject lands. But this is a categorical finding that is recorded. But fact of the matter remains, as I submit to your lordship, the proceedings are initiated for rectification of the entries of the Kasra, which is fraudulently brought into, has been taken by the grandfather of the petitioner himself in the year 1968 itself, that is prior to the coming into the force of 1971 Act. And so far as the Act is concerned, the proceedings that were contemplated and updation of the records and maintenance were not. So far as that is concerned, this is the finding that is recorded with the learned judge. The factual fact of the matter is that the names of the predecessor and title were recorded in the Kasra for the year 1954-55. The Kasra Pahani is the record of land ownership. Basing on the Kasra Pahani, it appears that the names of the predecessor and title of the petitioner continue to be reflected in the revenue records for the subsequent years, though intermittently. It is not there. The Vasool Baki and Setwar, however, present a different picture, as only name of Janga Reddy, the grandfather of respondent, is shown as Pattadar and possessor. But the effect of Vasool Baki and Setwar, but is unlike the Pahani. But so far as the Vasool Baki and Setwar are concerned, Millard, this is what I have extracted also, Millard. They are the settlement records. They are not the revenue records, and they are the settlement records. And Setwar is a document of title, Millard. But as held by this honorable court, Millard, in state of Andhra Pradesh versus Pramila Modi, and that judgment of this honorable court, Millard, was confirmed by the Honorable Supreme Court in state of AP versus Pramila Modi, reported in 2006, 13 SCC 147. But this, therefore, this Setwar is recording the name of the third respondent's grandfather. But it is also recorded, but the effect of recording of the name of grandfather in the Setwar as Pattadar possessor has not been considered by the learned single judge in the right perspective. Present different picture as only name of Jagga Reddy, grandfather or respondent number 3 is shown as Pattadar and Professor. Thus, there is a discrepancy in the revenue records, which by its very nature was not immediate.
Continue after the break.
Very.
Acha, 1 minute. We have some lunch motions thereafter. Yes.
The matter is thought by law firm Miller order,
Which order?
page number 29.
Item 1. Page
29.
29. Yes, madam. Disposed of certified copy today. 2.
228.
28.
Page number 22, madam.
Page number
22, madam.
22. Okay, disposed of. 4.
27.
27. Certified copy today. These are the page numbers. Ah, yes, Mr. Ah, you were reading.
But I was reading.
Ah.
At page 40.
No, 36. 36, Mr. You have already read Shetwar and Vasool Bakiyar. You have told us these are the settlement record and documents of title. All this. Only 3 pages are left. You read it. I want to read. You are reading the whole thing, right? Up to.
I was referring to the findings that are started and the which are against them.
Ah, yes.
But this is the judgment that I was referring to.
Ah. All right. Yes.
There are 56 to 58 findings that are which are read to your lordship that the Shetwar is equal to
Is a document of title, right?
for the proposition, my lord, that Shetwar cannot be equated to that of the media speaking record.
We have understood, Mr. It's a settlement record, and in other words, it's a roughly, it's a document of title. It cannot be created with a, equated with a entry made in revenue record.
And my lord, the findings that is recorded, my lord, by the learned single jet is contrary to this.
Yes.
That's what, my lord, I have referred to your.
All right.
Page 35, internal page 35.
Yes. Yes. Now next.
And then, my lord, your lordship may kindly see that the page 36 minute I was there, and page 37, main page 48 minute. Similarly, the petitioners in the present case, page 47 minute, last 2 lines. In the present case, father of respondent Ramchandra Reddy admittedly died in 1979. No application seems to have been made with the respondent under section 4 of the Act, claiming right of succession thereafter. Similarly, the petitioners and respondent number 4, who claim to their predecessor Gopal Reddy and Siddha Reddy, also failed to take steps in this regard after death of their predecessor in title. As the matter stood, thus some of the revenue records showed the name of respondent number 3's grandfather and his son title of the petitioner as Khattadar of the subject land. Here also, learned judge referred to my Vasool Baki and other revenue records also as mere revenue records. But an appeal was filed by the respondent number 3 under section 15(2) of the Regulation Act. The 15(2) of Regulation Act 1358 is extracted. Kindly, you Lakshmi, kindly see 15(2), the collector to the same authority who has dealt with Mirad in the present case also, remanding the matter to the MRO. Under the old act, the entries that are sought to be challenged, that are sought to be corrected, are the entries that are made under that earlier, not under the new act. And under the earlier act, the collector may on his own motion or an application of a party call for and examine any records under 4 and 6 of the act. But the power of the collector under 15(2), that is is for any entry that is made under 4 and 6. But that is one, my lord, that the application that is made is only for that purpose. And further, my lord, in the next paragraph, there is no provision in the 1971 Act which is identical to section 15(2) of the regulation 1358. Though Rule 13 of the rules of 1989 seems to grant a general powers of supervision which could be exercised suo motu by a host of revenue authorities to test and revise the entries in the confined record. There is no provision in the parent statute, the Act of 1971 conferring such wider powers. But this finding in my respective submission is contrary to section 9. And section 9, the power of section 9 under the collector is also more than 15 of the old Act. But my respective submission that though section 9 cannot be said to be applicable, in the alternative 15, since the revenue records, the correction of revenue records are sought in respect of the entries that are made under the old Act, the application that is filed under section 15 is entertainable, and even there is a learned single judge of this honorable court who took the view the application filed under 15(2) can be considered as an application, can be considered by the joint collector under section 9 of the Act, which is a learned single judge. That judgment is also not considered by the learned single judge. And this finding that there is no provision in the Act is also not contrary to section 9 of the Act, which provides and which retains the power of collector of revision. In any event, the power conferred by Rule 13(2) is with regard to the revision of entries in the confined record of rights under Rule 13(1). As stated, there is no material that is placed. But so far as there is one another fact is concerned, my lord, that the petitioner and their father have filed a declaration under 1973 Act, which is a Land Reforms Act, my lord, and there is a rule under Rule 9. That Rule 9 is the entries in Rule 9 are subject to the proceedings under 1973 Act. But that Act, there is a finding that is recorded by the learned single judge also, that the petitioner and their father have filed a declaration, and those people have been declared as non-surplus holders, and the present subject matter of the land is included in the computation of the holding which they have filed in a declaration under the provisions of the Land Reforms Act. But that you will also find at page 70. But so far as the finding is concerned with regard to the service, my lord, again in para 49, last para, that is one I did not wish to read, my lord. And then para 50, page 50, second para, the order reflects that the Bahanis of for the year 1968-69 and also showed the names of some 3 persons in the column pertaining to the name of the Pachadar, while the name of the respondent number 3 alone is shown in the column pertaining to the name of the cultivator. Having extracted above,
perhaps you should answer at page 46, internal page 46, this thing. In page 57, which says complex and serious disputes.
Yes.
What does it say?
But so
read it and then answer.
Yes, complex and serious disputes of title falling beyond the ambit of Rule 9 of Rules 1989 are not within the ken of adjudicative authorities of revenue authorities, even under the Act of 1971. It is for the parties to initiate appropriate proceedings before a civil court of competent jurisdiction to resolve the dispute, and it is not open to either party to turn to the Act of 1971 to steal march over the other. Needless to state, in the event of either party approaching the civil court of competent jurisdiction, it is open to them to raise all issues and contentions raised in the petition, including the effect and consequences. Same would be decided independently without being. But this observation of the learned single judge is contrary to firstly the record and does not arise for consideration in a writ petition under 226, but for 2 reasons. One, here is a case where the respondents have already initiated proceedings for resolution of their right in the form of OS, and that suit is dismissed for default, and that has been recorded by the learned single judge also. So the rights which they have tried to assert before the civil court have been adjudicated in the manner in view of a dismissal for default. Therefore, they have
Dismissal of default entails adjudication, according to you. When a suit is dismissed for default,
yes,
then the rights are adjudicated.
but so
It is not so, Mister.
no, he has
Saying that it attains finality, saying that it is same cause of action, he cannot file a fresh suit, that is understandable. But you cannot say that there is an adjudication where he has decided that they are not entitled to rights and therefore dismissed.
but so far
It
as
is for default right.
no, but the observation that is made by the learned single judge, it is for the parties to initiate appropriate
No.
proceedings before a civil court. But now the law is that he is debarred from filing a suit for adjudication. Now, having initiated proceeding,
So everything has to be decided under this act only, title, etc. It is to be declared. Fine.
beg your pardon.
So he is debarred from filing civil suit. So what? Proceed, Mister.
No,
We have other cases also too. Go ahead. Then, so therefore, the authorities under the act have jurisdiction to decide the question of title.
But here is the case where the authorities have not decided the question of title, but the authorities have relied upon. Kindly see the report of the revenue inspector dated 1/2/1967 and report of the Tahsildar dated 21/3/1967 and the order of the joint collector dated 30/4/1963.
A question of title has not been
It
decided.
is not the fact, my lord, it is a report that is submitted by the authority under the act. My lord, that report is to the effect that the father's brother, Surendra Reddy, was a Patwari and he is the person who has manipulated these entries. But this is a report that is furnished, my lord, before the authorities in terms of the provisions of that act. And on the basis of those reports, those entries are sought to be corrected. And these reports are there glaringly. And the division bench of this honorable court, which I have read to your lordship, that is 1994 4 ALT 209 division bench, wherein this honorable court took the view, merely because a civil suit is there, the authorities under the act are not debarred from inquiring into and deciding their case, subject because that adjudication is again subject to the adjudication under 8 of the act, that is contemplated under the act itself, because the orders passed by the authorities are subject to the adjudication by a competent civil court. That is there. But now the factual reports are there to the effect that the entries that are made in the name of their predecessor are fraudulent and obtained and they are resultant of the Patwari, who is their father's brother, Surendra Reddy. That finding of a fact that is recorded by the authorities under that act, that is staring against them in the teeth of that, and the adjudication which they wanted to seek is also ended in dismissal. But and so far as declaration that is there, that is filed under the LRT Act, that is also there, which proves that the appellant and his father was declared as a non-surplus holder. And furthermore, Millard, the MRO has conducted a spot inquiry as is required, as he is entitled to under the rules. He has conducted a spot inquiry and also found that I am in possession of the property. That is also there, and that factor also is not disputed by them even in their writ petition. And Millard, yet another factor is that they have not the order that is passed by the joint collector, Millard, workload itself, Millard, for the reason that he has participated, he has not raised objection.
We have noted it down, Mr.
Yes,
don't repeat.
This judgment, Millard, I may only for ready reference of your lordship, which to the proposition that dismissal bar.
There is the provision itself says, what judgment? We are agreeing with you The writ petition, the learned single judge has not granted them liberty to file a suit on same cause of action. What are you challenging here?
No, this is,
If they file a suit based on same cause of action, in that civil suit, you raise an objection that it is barred. Not here. That is not the question which arises. Agreed, same cause of action. If a suit is dismissed for default, the fresh suit is barred. That is what 9A rule, order 9, rule 8 provides.
and it binds not only them and the successors who are claiming through them also. But here is a case, my lord.
Yes. Yes.
But and the but I would only take your lordship, my lord, with regard to the possession aspect, my lord, which has been recorded by the Mandal Revenue Officer. He is at page 54, my lord.
Read, Mr.
But the
Everybody else is waiting for you to conclude. Yes, go ahead.
The order dated passed by the Mandal Revenue Officer would show the Mandal Revenue Officer personally conducted a Panchanama regarding the position of the subject land as provided under Rule 21C. Having conducted this inspection, Mandal Revenue Officer recorded his finding. The respond number 3 and prior thereto is petitioner were the owners and possessors of subject land, and also the petitioner have never been in possession thereof. In this connection, it is relevant to note it is not the case of the petitioner that they were in possession of the subject lands. According to them, they are joint owners of the subject lands along with respond number 3, and they specifically assert that their position is one of joint owner, cannot be exclusion and adverse to other. Therefore, spot inspection could not throw light only to the fact of the position which was not even in dispute. But the so far as another finding, my lord, which is recorded by the learned judge, that that Usul Baki is only a mere entry at page 55 also, my lord. At 3 places, learned judge recorded the Usul Baki and Setwar, but yet says it is not, it is only a revenue record, it can't be an high pedestal. And the learned judge interfered with the order of the joint collector, but after it worked out itself on the ground that joint collector inherently lacks jurisdiction. But that finding of the learned single judge that the joint collector inherently lacked jurisdiction, is not sustainable in law. And so far as the order that is passed by the MRO is concerned, under the Act, the after revision is remanded and after the MRO passed the order, the order of the MRO is appealable to the RDO. But there is a remedy of appeal that is available, and 2 orders are challenged, in the present writ petition. Both were set aside by the impugned order, but without appreciating these legal submissions that are made.
Yes. 10 minutes, Mr. Not beyond that. You conclude. We have read everything. He has read everything from her. Yes.
Well, the simple case is that whether the revenue authorities are conferred with the powers under the 1979 Act to go into the complicated and disparate questions of fact. That has been decided by the learned single judge that the authorities have no jurisdiction under 1971 Act. And I am also relying upon various judgment of the Honorable Supreme Court where the exercise of powers Milord, this application, very application moved by them was under the Milord repealed enactment. In the year 1988, they moved the application, whereas under the 1971 Act itself, that provision was, that entire Act was repealed by virtue of Section 13 of the 1971 Act. Despite that, Milord, they moved the application. The Joint Collector, Milord, converted that application suo motu under Section 9 of the Act, which is, Milord, again, is beyond the powers to be exercised under the 71 Act. There is also, Milord, very much found by the learned single judge. Therefore, Milord, the settled law, Milord, the recent judgment of the Honorable Supreme Court in 2015 SCC in Nursing Rao cases, Milord, exercise of powers have to be within a reasonable period is also, Milord, record I have supplied the judgments of the Honorable Supreme Court. Propositions have questions of law. In the brief synopsis, Milord, I have prepared. Whether the revenue authorities have power jurisdiction to decide the complicated questions, and for that, Milord, I have relied upon various judgments right from Milord 1969 SC 1297. Then, Milord, the 1954 Supreme Court for the proposition that an order which lacks inherent jurisdiction would be nullity, and two more other judgments of the Honorable Supreme Court, Milord, with reference to paragraphs. Then, Milord, the reasonable time, Milord, again, in Patel Raghunath case 69 Supreme Court, Milord, till recent judgment of the 2015 3 SCC 695. Then finally, Milord, when Act is repealed, that has to be understood, Milord, it is as if it has never existed at all. For that, Milord, I have relied upon, Milord, 2011 5 SCC 305 and 2019 19 SCC 626. Milord, for all these, the learned single judge, Milord, already decided, Milord, all the questions of law. Therefore, my respectful submission is, Milord, appeal has to be dismissed.
But I would not, Milord, the proceedings of the revenue inspector 67, Tahsildar, and the joint collector orders, Milord, are filed at page 113, 114, and 128, Milord. And the plaint that is filed by them is at 92. And 105, Milord, we filed a written statement denying, Milord, their relationship with us. And their status as to the members of the joint family was also decided. And the judgment also, Milord, we have filed when we filed the written statement, Milord, they did not proceeded further for adjudication of their rights. And Milord, learned single judge, Milord, in the present writ petition has gone into that aspect, Milord, which is precluded in a proceeding under Article 226, Milord. That judgment also I filed at and the proceedings of Land Reforms Tribunal, Milord, I have filed at page 111.
Okay, thank you. Right down. Submissions heard reserved for delivery of judgment.
Basic.
Notice has to be issued to the NLRs. You appear?
I appeared for third respondent.
Who has died? He will read. fresh instructions, Mister. How can he appear? Heard on IA 1 of 23. Notice, right? Person notice proof of service.
Petition ఉంది కదా 8 to 5. అది 8 to 5 రిటర్న్ ప్లీజ్ ప్లీజ్
Nobody is appearing.
Just put it in a small nutshell.
Huh?
I'll put it in a nutshell.
We'll dismiss it, Mister. Why to?
Why not? Very well.
Otherwise, we don't know. None
Yes,
for the appellant.
Connected matter is
You are.
I'm appealing for the respondents. The connected matter is dismissed and a case the order by virtue of a memo.
Connected matter which?
There must.
Is it WA 163/9, 2009?
Yes.
Hello. Against common order?
No.
Oh, then we have 2 years. None for the applicant. Mark is senior counsel for respondent. This
I appear on behalf of proposed appellant, Your Honor. I have filed LR petition 1 of 23.
allowed. Go ahead.
Lordship may have it next week.
No, nothing. No next week. Next week never comes. Like you have heard, no, tomorrow never comes like that.
Either Monday or
Today, no, this is the last day of this case. Just now we told your colleague, right? Same thing. He's sitting here to watch whether we make a deviation. No, nothing. No deviation for. This is the problem of the judges that they have to be consistent.
Because of
There is nothing. There is no reason why you are a young person who want to become. You have already enrolled as an advocate. We do not see any reason why you should not argue cases. Nothing. No reason.
File is being reconstructed because
No, nothing. No.
got-
No reconstruction. This is the construction.
We'll argue on Monday, Your Lordship.
No, nothing.
Finally, Your Lordship.
No. No question of forget about it. You want your presence to be recorded or you want us to pass an order? Choice is yours because obviously you are a person who will not amenable to reasoning and you will not argue. You will keep on repeating that Monday, right? That is forget about it.
Because there are even civil suits are also pending between the parties. We are yet to get all the documents, Your Lordship. That is the only reason we are. Second appeal is pending before this honorable court. And Lordship may have it on Monday, Lordship. Finally, we'll argue the matter.
This is this division which referred, no? It was referred what happened in Damma and Lokraj. It is still pending. No, that's a bit here, it's still pending. Good bench has not decided.
May have one last chance, Your Lordship. Lordship may have it on Monday.
Forget about it first. Sit down. You have the choice either to appear or not to appear. Don't appear. Go home. Yes. Heard on IA number 1. Should you want your presence to be recorded? No.
I leave it to your lordships. I leave it to your lordships.
Leave it to me. You are appearing before us. And standing, therefore we are. What's your name?
Abhishek, your lordships.
Abhishek, Learned Counsel for the applicant, heard on IA 1 of 23. For the reasons assigned in the application duly supported by case, if not arguing, start drafting SLP.
Unofficial respondents have filed suit for recovery against us.
What?
The suit was dismissed, again which they have filed.
You are claiming occupancy rights, mister. In respect of, you are an assignee from the Inamla. The law laid down by this court is that you cannot claim. That is the conclusion. Let him file a suit, you enjoy.
But let these observations not come in their remedial. Because they might seek a favor.
Yes, right. Maybe. One. Law laid down by learned single judge. Don't delete Supreme Court, you say, don't say. This difference. All right. The findings are recorded in an order for what purpose? Only for deciding the list.
Because interim order also specifically records that these findings should not be in their remedial. Earlier interim order which was granted in our favor here.
Now this is an order in your favor, right? This, mister, this, it is again, Supreme Court is required to say this so that you understand that and observations made in an order are only for the purposes of deciding that controversy. We are only examining the validity of the order passed by the joint collector, nothing else.
They might seek a remedial. That is the only. They might say that
nobody is saying, they are not even appearing. They may not, they will never know that 2009 appeal has been decided in 2023.
They are fighting for civil, they are fighting for civil courts.
And they are watching the proceeding live, right? Huh? YouTube channel. You say needless to state that the aforesaid observation. No, we can't. You have not filed a suit.
I filed a suit. They also filed a suit against.
That this is the law laid down.
My suit.
Needless to state that the observations made in this order have been made only for the purposes of deciding the validity of the order. See, it is so simple, right? You should focus on, you should focus on arguing a case instead of repeatedly saying Monday. Because what will we do on Monday?
Because the only difficulty was the
no difficulty.
Reconstruction of file.
See, mister, there is no difficulty now, no need of reconstruction also. You are a happy person leaving the court with the satisfaction that there is no need to reconstruct the file.
I'm not happy, but
not happy. You should be happy, irrespective of the result. This is not, that has nothing to do with your life, right? And happiness. Decision of a case, if an order is wrong, advise your client to go to northwards, like we told you, start drafting SLP. Whatever bundle, here is the bundle. Learned counsel for the appellant submits Bajrang Singh. You are Mr. Bajrang Singh Thakur, right? Learned counsel for the appellant submits that he has no instructions to argue the matter. The appeal is therefore dismissed. Yes. You want to withdraw?
Not withdraw, my lord.
Just you are like showing this thing like this. So we thought that you want to withdraw.
And pause in this this survive anymore. I just pass a short note on the chain of events leading up.
No, your this thing is sufficient, right? Statement is sufficient. You are for appellant.
I'm for the appellate.
Then your statement is sufficient.
But IA number 1 and 2 have been filed for amendment and see additional document. But
You are saying the cause does not survive, then why we should?
amendment.
You are not sure, right? We will.
Yeah, sure, my lord. The
1 minute. See, you don't even want to assess the court where the cause does not survive. You are one hand saying that cause does not survive, then saying amendment and IA I have filed.
amendment is only with respect to cost title, my lord, because it was earlier framed as Andhra Pradesh. The document to receive petitions is in fact a memorandum of compromise for the Lok Adalat in civil dispute. May be taken on record, my lords, in light of which the cause does not survive in this petition.
Dispute has been amicably resolved.
Yes, my lords.
So your statement is not sufficient because you are an officer of the court, not an officer of the court.
That in light of the, no,
You are not an officer of the court. You are no. You amend this just now.
Yes.
Heard on IA so and so amendment of the cost title. Counsel for the applicant is permitted. Terms of compromise are entered between the parties.
Okay.
Disposed of, that's all. Don't. Amendment, Mr.
I'll just do it right.
Do it. Otherwise, you will never do it.
May I please? But this appeal Millard filed against the orders passed in writ petition 183/2002, which was allowed. The brief facts of the case, Millard.
So what is the outstanding amount now? 60 crores?
Must be crores, Millard.
Huh?
The
You
principal
you are
outstanding.
sure that you must not have complied with the directions?
No, we have complied, Millard. I have filed the papers also. I have complied all the directions given by the honorable.
No, single judge.
Millard?
Single judge.
Yes, we have complied.
You have furnished a statement of account to him on 31/12/98.
I have filed all those documents, Millard, before your lordship.
No, what is the 31/12/1998 account? Statement of account, what does it show?
The total outstanding, Millard.
No, 31/12/98, Mister, come to page 20, final part of the order asked by the learned single judge. Petition is allowed in following terms. Number 1.
Yes.
So what action taken by you is in violation of a decree passed by the civil court. That's why it has been set aside.
No, Millard, that was the only issue, Millard.
No, but have you complied with the direction?
We have complied with the directions.
Please tell
Millard,
us.
I have filed the documents. also,
31/12/98, what is the amount due?
Millard, I have filed a statement of.
Come to page 20, Mister, what we don't know, last portion of the order, can you read? For our benefit, we have not read it.
Page number 20, Millard. Judgment, Millard, of the honorable single judge.
So have you, what is respondent shall furnish? Read it, Mister. If you have not read it, please read it. We are putting queries in this context only.
Yes, 1 minute.
You are saying
The
we have.
respondent shall furnish the statement of account as on 31/12/1998 without leaving any penal interest within 2 months. We have complained, I have filed the copies also.
Where is that? What is the amount we are asking you? What is the amount, Mister?
That is just one. Millard.
Why is it standing in front of? What is the amount? 31/12/98. Huh? No, 31/12. You have also not read it, right? Fine. All right. No, not necessary for you to read, right? You have a right to claim ignorance and appear without preparation of the case.
No, Your
We have done our,
studied
we have taken oath to do justice. You have not taken oath, any oath. Yeah, 31/12/98, what is the amount?
Millard, the principal outstanding is 3,22,010 rupees.
3 lakh
22,010 rupees.
10 rupees.
Yes.
All right.
Interest part, Millard, 7 lakh.
Petitioner shall submit
753.
without levying any penal interest, Mister. We are asking you 3,22,000 is the amount.
That is the principal. Principal amount. Principal outstanding, interest is 7 lakhs, Millard.
Now saying the crores. It's very tough time. Unfair, like they are by their conduct telling that don't come and don't obtain loan from us. We will drag you till you are alive in the court.
His complaint report I have filed in the year 2020-22, Millard. These papers are available. I have completed all the conditions, Millard. We have
So what is the ground of challenge to the order of single judge?
Yes, Your Lordship may kindly see the second observation made by the Honorable Single Judge Millard. The petitioner shall submit a statement as to the loss incurred on account of seizure effected in violation of decree in OS 874 1992.
So senior officer has passed an order?
Yes.
When? There is no question of levying any interest, Mr. You are saying 7 lakhs, it is set aside.
Because that is not the penal interest. That is the interest charged as per the contract.
See clause D. Clause D.
There is no penal interest. We have not charged after the order passed with the Honorable Court.
Clause D of the directions, Mr.
Yes. A senior officer of the respondent corporation at the state level shall take both of them into consideration.
So has he passed an order?
Yes. On 22nd May 2009.
What is the order?
Order below, it is a detailed order.
He has not challenged the order. This is wrong. Because they are including interest on. But he is not challenged it. That's not good for us. Now, so the total amount comes to 3,28,000.
Your Lordship,
Where is the amount? Have you paid this principal amount of 3,22,010 rupees?
Your Lordship, the total amount is paid off, Your Lordship. Your Lordship, may kindly see page 54 of the writ appeal bundle here.
All right.
We have prepared a statement as to what are the.
No, we will say if not paid, already paid. Mr. Yes.
Okay. Blood.
So you have complied with the directions.
Yes.
Now what survives? Nothing.
Now, below, in view of the order of this court, they are not paying a single pay. Amount due has gone into crores. Now the unit is there in their possession because since the seizure was declared as illegal, the unit has been handed over to the respondent. Now they are enjoying the property without paying any amount to the corporation.
It is their property, not belonging to the corporation.
But
why they should not enjoy?
Let them pay the also. Let them repay the amount borrowed by them.
Their liability according to us is only 3,22,010 rupees plus 6,900.
No, but see, regular interest is between 12 to
Mr. Clause D, you are not reading, then arguing. Please read Clause D of the directions. Clause D.
The levy of interest subsequent to 31/12/1999.
Set aside.
No, we have not charged any penal interest.
No, it doesn't say penal interest. It says you are not entitled to interest.
No. The levy of interest. Yeah. Yes.
See, Mr. You are an officer of the court. You have to be fair. This is what it means. 7 lakhs you can't claim. That's why we are saying, Mr. C. Mr. Counsel, please listen to us.
This statement
is 1 minute. Principal amount is 3,22,010 rupees.
Yes.
Right?
Yes.
Damages on account of illegal seizure 6,900. Yes. So this amount has to be adjusted from 3,22,000. Forget for the time being interest portion. That we will decide whether you are entitled to charge interest or not. So the remainder amount to be paid by him is 3,14,110. And on this amount, as per according to you, interest.
No, but interest is charged only up to 31/12/1998 only. That is the amount 7,18,000. Subsequently, we are not charged. The statement of account is of 31/12/1998.
Where is that? That is the.
Order I have given.
No, you have to place it on record. Where is it?
It is there. I filed on 22nd March 2022.
Even this is considered. 23 means 8,003. If you consider any day, it's 21 years. Yeah. Subsequently, the directions have been servant. This is brought on record by the. And this levy of this he has to show if it includes the interest, then they have to pay. If not already paid, you will pay to that question. Where is it that interest is up to 31/12?
These documents are filed.
Page. Which page?
This is page number 2, Millard.
Page 2.
Page number 2, the abstract, Millard. Principal, interest to other expenses, CGC, CC, the total outstanding. On top of it, it states outstanding as on 31/12/1998.
Yes.
This is the amount he has to pay.
Lordship, I
We will
kindly
say-
refer to page
We will
11.
not enter into this aspect whether you have paid or not, because we are not this thing you produce the receipt. You are entitled, you are liable to pay this amount.
Your Lordship, I kindly refer to page 11 of the writ appeal. Yes,
Mister, we will not go into this. We are telling you, we will not go into this question.
Yes, Your Lordship, but there are
whether
certain
you have paid.
observations by the Honorable Single Judge, Your Lordship. I kindly refer to them once. Your Lordship, page number 11.
Mister, he is saying that now they have complied with the directions
Your Lordship,
issued by learned single judge, therefore nothing survives for adjudication.
Lordship, kindly grant.
And we will only say that if you have not paid this amount which is due under this, you will pay it. That's all. That's it. Or we will grant them liberty to recover. You recover the amount. That with their liberty, nothing survives for adjudication in this
Except
appeal.
this amount, Millard.
Whatever. So you have the powers under the Corporation Act. If you find that amount is due, recover.
Your Lordship,
This order of attachment has been set aside. Mister, in the appeal, you cannot be granted any relief, further relief.
Your Lordship, my request is only for the dismissal of this appeal, Your Lordship. Your Lordship, this statement of account, Your Lordship, was ordered to be produced
Mister,
in 1998 itself, Your Lordship. This statement of account is produced in 2009, Your Lordship. And further, Your Lordship, the principal amount is separated and the interest amount is separated. And further, Your Lordship, in the interest amount, sometimes they show credit balance.
When it has been produced?
In 2009, Your Lordship.
2009 has 365 days, Mister. All 365 days it was produced continuously.
By Your Lordship.
Date?
26 February 2009, Your Lordship.
9. Okay. You have to be specific, Mister, in law.
Lordship.
Like, you can't say like 2009.
Your Lordship, in page number 5 of their additional material documents, Your Lordship, the statement.
Mister, according to them, they have implemented. Why we should go into this question?
Your Lordship, this statement itself is non-compliance, Your Lordship. This is not compliance.
Mister, no, you have, is it correct that you have implemented the directions contained by learned signature?
Yes.
Therefore, nothing survives for adjudication.
Your Lordship, these are not exact compliance, Your Lordship. They have submitted a statement with.
Mister, it's his appeal. If he doesn't want to press it, you cannot this thing be after. No.
It
You
may be
prosecute
dismissed,
your
Your
appeal.
Lordship.
We are recording a statement that they have, according to them, they have complied with. If you, according to you, not comply with, do whatever. You have not challenged the order passed by learned single judge.
We have filed. Yes, sir.
You have also filed an appeal.
No, Your Lordship,
Right?
the rate appeal.
You have accepted the order, it's his appeal. He doesn't want to press it. Doesn't want to be, since they have complied with the directions. He doesn't want to. We will say that nothing survives for adjudication.
My only interest, my lord, I have to
One
recover
day.
that amount, my lord, that's all. I have to recover that amount, whatever is.
We need not tell you what to do.
Because
If
of the
you don't
order,
have-
my lord,
Mr.
to take any further steps.
Yes. Correct. Nothing survives. Yes. This intra-court appeal has been filed against a judgment dated. You understand, right, Mr.?
Lordship may kindly say.
Nothing, we have said remedy available in law. You take
recovery, the word
remedy. We are not determining what is the amount
But
due.
the problem is, Milord, by taking advantage of this order, Milord, we could not do anything, Milord.
We have said, Mr. If you don't have powers under the SFC Act to recover any amount, file a civil suit, do whatever. We have said you take an action for recover. It is open for the parties to take. It is open for him to challenge your order also, which he is not saying. But that's why we have left both the parties to take recourse to the remedy.
At least you
The scope of appeal was. The short point is no.
At liberty to proceed.
That you don't need. You are the this thing, no. Counsel for the, you will advise them.
They try to take advantage of this.
No
What
advantage.
says that the corporation is at liberty to proceed.
No.
That will certainly
Means liberty to proceed means we are holding that he is under, he has not paid. He is saying no. It is made clear. You write one sentence, it is made clear that this court has not expressed before that liberty sentence. It is made clear that this court has not expressed any opinion with regard to the amount payable by either of the parties to each other. That's it.
we need not pay anything, Milord. They have to pay.
3,000 rupees. So this thing damages, who will pay?
Your Lordship, we have even submitted a letter as per the direction. Yes. Direction D of the writ order, Your Lordship. It's my only submission.
Arey, Mr.
Lordship.
Nothing survives for adjudication. We need not travel beyond the scope of the appeal and find out work like a cost accountant, whether they have paid the amount, how much amount they are entitled to recover. All this is kept open. Please appreciate. Yes. Oh.
But this order, Milord, is passed, Milord, without notice to us.
This order
stage.
2009.
Yes, Milord. But the order is passed, Milord, without notice, Milord, at the admission stage.
Fresh application.
Yes, Milord. It has to be. That's what, Milord, you will ask for.
No. You are what? Mani Prasad? No.
No. I am L. Prakash Rao.
L. Prakash.
Yes. Has to go back.
What is the order?
The order is, Milord, for a dial
survey of the land.
Survey.
So you are saying that he is not in possession and he has no right to claim survey.
He has no right to claim survey, and he has filed a suit also. That also he has suppressed.
Oh.
That suit.
Was there a stay?
Yes, Milord. Yes, Milord. There is a stay. There is a stay.
When? There shall be interim suspension as prayed for.
So that's what.
Yes, madam, right. This intra-court appeal. Correspondence number 1 and 2, you have written 3 and 4, you write. Read petitioners, right?
And we shall be given an opportunity to file counter. The Lordship said opportunity of hearing, but counter also will file.
Goes without saying, right? Huh?
Because that is being.
No. Yeah, what do you think that single judge after remand will say, no, you don't have a right. You only have opportunity of hearing. Don't be like a child, right? Ah, yes. Yes.
Sir. My lord, I beg to appear in item number 34.
Ah, yes.
My lord, this is an intra-court appeal filed by the writ petitioners. The background facts are this, my lord.
1 minute. Give us 1 minute.
Yes, my lord.
Yes. So what are the grounds of challenge to the order?
My lord, the order is not challenged in toto. Only a partial relief is claimed in the writ appeal.
Ah.
The
Criminal prosecution.
Only prosecution, my lord. What happens is this. Mandal Revenue Officer, my lord, has granted migration cum caste certificate to the writ petitioners and writ appellants. And this grant of migration cum caste certificate is faulted by the appellate authority, that is the district collector, in the order dated 25/4/2002. And he finds fault saying that there is no concept of grant of migration cum caste certificate, because grant of caste certificate is under a local law, and migration certificate is not within the purview of the authority of the Mandal Revenue Officer at all. And finally, by the impugned order in the writ petition dated 25/4/2002, the Tahsildar's grant of migration cum caste certificate in favor of the writ appellants, writ petitioners, has been set aside.
Yes.
There is no grievance, my lord, to this extent. And while setting aside that, kindly see, my lord, page number 33 of the writ appeal material papers, the last paragraph of the impugned order of the
Page.
Yes, page number 33, 33, my lord. the last para in bold, it reads like this at page 33. Therefore, my let's got this minute.
Yes, we have read it.
Therefore,
Prosecution.
the migration cum caste certificates of ST, that is scheduled tribe Lingadwari Koya, as the case may be, obtained by you from the Mandal Revenue Officer Cherla are hereby cancelled and ordered to initiate criminal prosecution as per the AP SC ST BC Regulation of Issuance of Community Certificates Act 1993 and the rules. Well, the petitioners have applied for migration and caste certificate and they were granted. They were set aside. Then, while setting aside, Malad, the appellate authority has directed the prosecution of the petition.
Correct.
And the matter was carried before the learned single judge in the writ petition. And in the writ petition, Malad, the learned single judge at page number 7, the judgment starts. Kindly see only one particular page, page number 16, internal page 9. Last 3 lines.
Internal page?
Internal page 9, Malad.
9.
Running page number 16. Last 3 lines. Rehearse these certificates. If the petitioners have any other material to support to claim a community certificate as ST, they are at liberty to do so. On the basis, this is the observation made by the learned single judge that rehearse these certificates which are cancelled. If the petitioners have any other material to support a claim for community certificate as ST, they are at liberty to do so. Then next page, Malad. But on the basis of these certificates issued by the MRO, Kerala, the petitioners shall not be entitled to claim ST status. The impugned order of the first respondent is impeccable and warrants no interference. Hence, there are no merits in the writ petition. The prayer made in the writ appeal is that the writ appeal may be considered by the Honorable Court only to the extent of the of prosecution of the petitioner.
Fine. Yes. Supposing if somebody, there has to be an element of mens rea, like something for commission of an offense. If somebody applies to your authority and gets an order, how he can be prosecuted, supposing if the order is set aside? This you will agree, Mr. No case for prosecution. They are not now this thing challenging the order so far as this thing. And once learned single judge having granted the liberty to establish the claim, ought not to have directed criminal prosecution. There is no element of mens rea, Mr. There has to be something like what is this thing recorded by the collector that they have with a criminal intention.
With Lord's permission, may I assist, Lord? The special act, the Telangana Scheduled Caste, Scheduled Tribes and Backward Class Regulation have a power to initiate a criminal action against the appellants.
Merely because power is there for every case. What case? Which provision?
Section 10 of the penalties. Section 10.
Which, madam? So that power is there.
Yes.
What else?
Whoever obtains community certificate by furnishing a false information or filing a false statement or any other fraudulent deeds shall on a conviction be punishable with rigorous imprisonment for a term which shall not be less than 6 months, but which may extend it up to 2 years, and with fine which shall not be less than 1,000.
That power is there. So fine. So therefore the order is correct. What is the submission? Section 10 power is there. That's all. What else?
Well, one way is admitting the appellants obtained a false certificate. He is admitting one way. Other way
not admitting. Not admitting. Liberty has been granted to him, Mr. You have not challenged the order of the learned single judge saying that the even liberty should not have been granted to establish his claim. There is a limit to being reasonable, Mr. You are a government advocate.
Learned single judge is
No, your government vouchsafe itself for the benefit of these people. And you are, this thing, shall we say that this is the stand of the government advocate, that he is seeking prosecution of these 24 persons. lighter when we are saying there is nothing in the case. Yes.
So this
Nothing in your case. Fine. If we have recorded, we will record your submission, whatever you have to say. Eventually, we have to decide. You cannot decide that I will send them behind bars for 20 years. You can't decide.
But my endeavor before this court not to make up the crime in the future.
Huh?
Not to make continuously for in future. Because there is a provision for the penalties. Otherwise, he has to take a lenient view to commit a further crime. That's our endeavor before a law.
We will record this also. What else? This if the order is conviction is set aside, if their order for registration, others will be tempted to make for application. This is the submission.
Already registered a crime against the appellant.
No,
There
no,
is a
no.
register.
Your submission, we are trying to understand that if supposing if we interfere this part of the order, the others will be tempted to make false applications to obtain and filing a petition in writ appeal before this court, right? This is the submission.
No, it's not like this, right?
You are saying that others will be encouraged. All right, this intra-court appeal is filed against an order dated